Good morning, everybody. It's time for the inquiry to resume. Can I just check that everybody can hear me? Everyone's nodding. Thank you. And can I just check that the live stream is working? Thank you. Thank you very much. Just a usual reminder to everyone, if you could make sure that your electronic devices, phones, laptops, etc., set to silent, that'd be very helpful. For those of you who haven't been to this venue before, we're not expecting a fire alarm test. So if you hear the fire alarm, if you could please evacuate. That's the nearest fire exit. Just be careful of any cables that are in front of the door if you need to go there. I've got a few procedural matters to do and a couple of updates. The first thing I just wanted to provide a brief update about site visits. As people will be aware, we carried out some accompanied site visits right at the very start of the inquiry. And also myself and Mr. Clegg have carried out some unaccompanied site visits in the previous week. On Monday, we made some further unaccompanied site visits where we took some bus journeys into and out of Cambridge from Cambourne and to Cambourne, including bus journey at the evening peak times. And we also took a journey or a couple of journeys on existing guided busway services that operate from the centre of Cambridge to places outside Cambridge. Then on Tuesday, we undertook a series of accompanied site visits, accompanied by a representative of the applicant and of the Cambridge past, present, and future. And we on those we visited Bourne Airfield, the Burford family home on Madingley Road, Coton Orchard, the Sadler family land at Rectory Farm, including the proposed location for replacement public open space, and Clare Hall. And then yesterday, myself and Mr. Clegg undertook more unaccompanied site visits, which included taking the viewpoint from the top of Red Meadow Hill, viewing the existing open space land adjacent to the M11, having an in-depth look along Madingley Road, where the Cambridge past, present and future and Coton Parish Council alternative scheme has been put forward, and that included walking the footpath alongside the Madingley Woods Triple SI and the American Cemetery. We also had a look at the proposed route along and parallel to St Neots Road at Hardwick, including viewing existing lay-bys and parking arrangements, including the Ashfield veterinary practice, and other parts of St Neots Road adjacent to the route, Scotland Road, and the footbridge over the A428 to see the proposed park and ride site, as well as the vicinity of dwellings at Childerley Gate. So myself and Mr. Clegg are satisfied that we've had an opportunity to have a fairly comprehensive view of the site, other sites that have been made reference to in terms of alternatives and the surroundings. And I think we feel we've had quite a comprehensive view. I just want to double check to see if there's anywhere that anyone feels it's necessary for us to visit, which you don't think we have visited rather. I'm just looking around the room. I can't see anyone making indications, so that's happy. I mean, in the unlikely event, or in the event that we didn't need to make any additional site visits, those would be taken on a unaccompanied basis after the close of the inquiry. In terms of the proceedings today, as was mentioned at the end of last week, the formal consideration of evidence has finished. That is evidence where witnesses have been called to give evidence, and that evidence has been tested through cross-examination. Today we've got on the agenda two what we call roundtable sessions, and that's followed by closing submissions from or on behalf of the Mayor of Cambridgeshire and Peterborough, Coton Orchard and Houston Crest Properties Limited, J and W.R. Sadler, Cambridge Past, Present and Future and Coton Parish Council, who are jointly represented, I understand. South Cambridgeshire District and Cambridge City Councils, also jointly represented. And just a reminder, in terms of the rules under which this inquiry is being carried out, there is a requirement for written copies of any closing submissions that have been made to be provided. So we will be expecting those. In terms of the roundtable sessions that we've got on the agenda for this morning, I just thought I would say a few words for those of you who are unfamiliar with those. I'm sure a lot of people in the room are familiar with them. They're still part of the formal inquiry, but as I mentioned, it's they're not where evidence is presented and tested through cross-examination. Rather, it's a discussion led by myself and Mr. Clegg as the inspectors to hear the information we need, in this case, particularly around suggested conditions for the deemed planning permission application and around the order which has been applied for. Just to give some comfort to those who, again, maybe not be familiar with the process, this is a standard procedure, and it doesn't indicate that myself and Mr. Clegg have made our minds up about the case, and it doesn't weaken those parties' objections to the proposal who are continue to oppose the proposal. Rather, irrespective of the panel's recommendation, should the Secretary of State decide to make the order and grant deemed planning permission, any conditions imposed on that planning permission need to have been considered carefully by all parties. What typically happens is when a report is made to the Secretary of State, again irrespective of what the recommendation is from the planning inspectors, the Secretary of State will expect to see a schedule of conditions, so that the Secretary of State, should they decide to grant deemed planning permission, has those conditions there. And there'll be a similar process for the draft order. Again, the order is the legal instrument that, should the Secretary of State decide that the proposal should proceed, it would effectively permit the development, and it contains various provisions relating to development, including provisions to protect the interests of statutory undertakers, for example, utility operators who've got equipment that might be affected. So that's just to set out what the approach is, and I'll introduce that in a bit more detail. Ms. Clegg.
Just one thing to add about the two roundtables. Unlike the previous formal sessions of the inquiry, it's an opportunity for anybody to participate in the roundtable, as and when they've got a point to raise. So please do take that opportunity if you wish to say something about either conditions or the form of the order itself.
I now just want to I'm just going to talk about some documents. Can I just check? Has anybody got any questions about the introduction I've given there to the roundtable sessions? Okay. As people will be aware, there's been a number of documents have been submitted into the inquiry, and I just want to run through those. We've received, in response to inspectors' questions relating to Mr. Lewis's proof and Mr. Sensicle's evidence, which was to do with a reference to a county wildlife site on which I think is called the Madingley Slip Road verge. We've received a note from the applicant of that. In advance of the session on the order, a number of documents have been provided by the applicant, including a schedule of changes to the draft order, a revised draft order in a clean version, so that is the revised order that's been provided by the applicant. They've also provided a comparison version of the order showing the changes between the previous and most recent versions, and that's been accompanied by an updated works and land plans drawings showing the removal of 2 national highways plots on sheets 9 and 10, and they've advised us that there's no other changes, but the intention is that the applicant's asking those to replace the former set of plans. The applicants will also provide an explanatory note which deals with a number of particular aspects. The applicants also provided 2 legal authorities or court judgments, which they intend to refer to in their closings, and those are Euro Garages Limited versus the Secretary of State from 2018, and R. Wyatt versus Fareham Borough Council in 2022. They've also provided 2 documents which have been published very recently by East West Rail. One is a You Said We Did autumn update, and the other is the 2024, if I've got that date right, consultation feedback summary report. That might have been a typo. I assume it's probably 25, but we've been advised they've only just become available. The applicant has also provided a response to the academic paper that was supplied by the CPPF and Coton Parish Council about the behaviour of barber-strel bats. So that's been provided as a note, and there's also been a written response to the representation made by a Ms. Marchant, which was mentioned at the inquiry last week. And the applicant's provided a copy of its response to Ms. Marchant's information request. East West Railway have also written into the inquiry withdrawing their objection to the proposal. And in terms of those documents, having considered them and considering the contents, I think myself and Mr. Clegg are minded to accept all of those, and they will shortly be on the website. But can I just check to see if there's any comments on any of those? I can't see anyone.
Sorry, briefly. I've only just seen the documents this morning, so I am just reviewing them. So if I just might have the opportunity to review them before expressing comments on the
Certainly, so what we'll do is
the responses, particularly to CPPF's evidence.
So what I think we need to be careful of is obviously if there is something that you consider to be new evidence, we have actually sort of finished the consideration, but I would appreciate any comments. I'm conscious there's quite a lot of documents. We haven't got much time, but it'd be helpful to know if there is a particular issue as soon as possible. What I propose to do is we'll continue to put those on the website so that everybody can see them. And then if I can check back in with you to see if there are any particular comments on those. Was there something in particular on that you were concerned about?
Well, just in general, to have the opportunity to see what the applicant said by way of response. I am literally, as we speak, reviewing the response on bats, for example, but I just haven't had that opportunity yet. So yeah. I don't know whether there's anything particular yet.
I mean, on the bats, I mean, obviously, that if you recall, you provided an academic journal article. The applicant has the final right of reply. I was taking that to be their final right of reply. But if you've got any comments on that, if you'd let us know at some point.
I would. I think the question is whether it's simply a response to the journal article. I want to check that no other new evidence has been put in responding to other points, that kind of thing. And scanning through it, there may be other points. So it won't be a further response to anything that the applicant has legitimately put in. It will be commenting on the legitimacy of the applicant's response and fairness and so on, that sort of point.
Well, Mr. Parker, what I'll endeavour to do, and if it slips my mind before we hear any closings, it'd be helpful if perhaps you are able to give us an indication of any comments on that. Thank you. Is there anything you want to add to that, Mr. Cameron?
Not on that. We'll wait and see, but I think it's probably the best thing to do on that. But as you said, a document came in from CPPF and we've responded to it, but we'll wait to see what Mr. Parker says. Can I just add, so on that list, it's comprehensive. What I'd like to say is that if, well, there are other changes that need to be made in response to the removal of the two National Highways plots, because the book of reference would have to be changed. Then the plans would have to be changed, just removing the plots. There's no mystery to this. And the other thing that needs to be changed there is the explanatory memorandum, because it doesn't at the moment reflect the changes that were discussed on day one. So we are planning to put in those documents, but we were going to wait until after the discussion on the draft order, but we can put them in now if you'd like us to put them in now. But as I say, as soon as one changes one thing, there's a whole cascade of other things that need to be changed, and we're just mindful of that. But they don't change anything of substance. Those are documents.
Yes, yeah.
I was just checking with Mr. Clegg that I think, as you anticipated, it's probably best to wait until we've had the round table session in case there's anything that comes out of that might necessitate any other alterations.
That's what we thought, sir, but thank you. And the only other thing to say, you mentioned closings, and there are various parties who are not professionally represented. I'm sure that they do understand that closings cannot introduce new evidence, but are submissions on the basis of the evidence given. I would be very reluctant to interrupt anybody in their closings, but look to you, sirs, if there is a departure from that principle.
And you've anticipated a reminder I was going to give to everybody before they start to give their closings. But thank you, Mr. Cameron, for reminding everybody about that. Closings, yes, are not an opportunity to change your case, introduce further evidence, try and change something that perhaps a witness has conceded on during cross-examination. It is an opportunity for all parties to provide effectively a summary of the case that they've made through the inquiry, and it is something that's very helpful for myself and Mr. Clegg, so that we understand the position at the end. But as Mr. Cameron rightly pointed out, it's not a way to either continue discussions, reopen discussions, try and, as I say, change positions, etc. Like Mr. Cameron, and it's not something that myself and I'm sure Ms. Clegg, we wouldn't normally be asking detailed questions when somebody's providing closing, unless there's something that does stand out that needs clarification. But hopefully people will just be able to present their closings. So thank you. So I think that's covered everything in terms of the introductions I wanted to do today. But before I start the first round table session, can I just check to see if there's any other procedural matters that anybody would like to raise? Okay. So
the only thing I would ask is that the documents you've referred to go on the website. I've been keeping a very careful eye on this, but some of them, unless I refresh, I might find they've suddenly gone on. Not all of them are on, I don't think, and it would be, another one's just come on.
Yes, I think Ms. Vincent has been busy putting those on, so I think everything should be on that we need.
Well, hopefully the information on the draft order will be on by the time we get to the draft order.
Yes, that's our intention. I think quite a number of those documents only came in yesterday. Mrs. Vincent's been working hard on them.
Well, we try to put them in slightly earlier than that. But anyway, if they're on by the time we get there, yes, that'll be fine.
Thank you. So, as I mentioned, the consideration of conditions is a standard procedure, and it doesn't indicate that we've made our minds up on the case. And just to repeat, it doesn't weaken the cases of any parties who've opposed the proposal. But it is a very important thing to consider. There is an agenda that has been published on the website for this for this session. It's a fairly brief one, and So I've got so many tabs open on my
But while
laptop.
while you're doing that, from the applicant side on conditions, be led by Mr. Stephen Roberts from Carter Jonas, and Mr. Ralph Lewis from WSP is here on the background as well.
I was going to ask for attendance in a second. So, yeah, as you'll see from the agenda, the intention is to look at the draft planning conditions, the latest version that was provided by the applicant, and myself and Mr. Clegg have provided some detailed comments on those, which hopefully again people have had the opportunity to have a look at. So that will guide our discussion. And those conditions provided by the applicant are the latest in a series of drafts of suggested conditions. The original or the early one was a set of draft conditions that came in with the application for the order. There have also been a set of draft conditions which has been agreed between the applicant and the district and the city, the city council. And then, as I mentioned, we've got the latest set from the applicant. And in terms of discussion, the round table is open for anybody who has any sort of particular comments. It may be helpful if you've got interest on a particular condition that we wait until we reach that one in the discussion. And I was now going to move on to attendees, and Mr. Cameron's already introduced his participants, but I'm afraid since then I've actually forgotten what you said, Mr. Cameron. So can you introduce your?
Yes, sir. The lead will be taken by Mr. Stephen Roberts, who sits to the right of Mr. Henderson, who's from Carter Jonas. And if there is information requested on background, Mr. Ralph Lewis is also here to contribute. And if there's a point on which we think we can assist, either Mr. Henderson or I may participate, but the lead will be taken by Mr. Roberts.
Thank you. And for the district councils.
Thank you, sir. I'm Chengi Taruvinga from the Shared Planning Service, and I will be dealing with the conditions for this session.
Thank you. And CPPF and Coton Orchard?
Yes, Mr. Littlewood, I'll be dealing with the conditions.
And is there anybody else? If you just hold on, I think we've got a roving microphone.
Good morning. I'd like to attend. My name is Mark Abbott, ABBOTT. I'm chair of Coton Parish Council.
And you sitting there just because there's not enough room with the CPPF and Coton Parish Council table?
I'm sorry, sir?
Are you sitting there because there's no room? I'm just wondering because the Coton Parish Council.
Conditions, not for the. I'm not going to speak as part of the inquiry submissions today.
No, that's right. My understanding was I was just double checking because throughout the inquiry, the parish council have been presenting evidence jointly with the Cambridge past, present, and future. My understanding was that that was what the people there were speaking to. I'm not saying you can't contribute. I'm just trying to clarify. I was just wondering whether you were sitting there because you could.
But in terms of the conditions, I'd like to sit in.
Yes, of course.
Yeah.
I don't think there's any problem.
I was just trying to clarify.
Yeah. If you prefer to me sit at the desk, I'm very happy to do so.
Councillor Abbott, there's no problem at all with you participating. We simply need to know whether you're participating as part of the joint parish council CPPF team, or as an individual councillor.
As a part of the joint effort. Thank you.
Okay.
Thank you. And is there anybody else? I can't see anybody else. Uh, thank you very much. Um, in that case, if I can ask people to have a look at both the draft the draft planning conditions, which have been provided by the applicant, and those are at where are we? Core document. Thank you very much. 2996. And there's also the note that's been prepared by myself and Mr. Clegg, which is actually available on the program, the inquiry program page of the inquiry website. And
Sorry, Stanley, where will you find that?
if you go to the front page of the inquiry website, then there's a list of about 6 links on the right hand side, one of which says inquiry program. If you click on that, then there should be a link to the program. Yeah, and there's both the agenda for this condition session and the order session later, and then on there there's also the inspector comments as well. Again, apologies for today. I've got so many tabs open on my laptop. I'm jumping around a bit. So if I can first look at the comments, and the first question that myself and Mr. Clegg have got is some general ones, and several conditions refer to the relevant local planning authority. And my understanding is that there's been an attempt to differentiate between those parts of the scheme that lie within Cambridge City and those parts of the scheme which lie within South Cambridgeshire district. And it's just a question about whether that's sufficiently precise approach. Mr. Roberts, is there? Do you have a view on that?
Not really, sir. In consultation with the local planning authorities, we've reached a conclusion that the wording is precise, and if anything, it probably provides a bit of a headache for the applicants, consultants, if anything. But for the purposes of understanding the condition and its requirements, we're content that it's sufficiently precise.
So if I can add, it also covers the position in the event of local government reorganisation, which may take place, and therefore it's, if you did put in the specific council, you'd have to put in or any successor organisation. So relevant local planning authority is probably better, given the.
No, we weren't thinking at all of naming local planning authorities for the very reason that you mentioned, Mr. Cameron. I think it depends how you hear the word relevant. We just wondered if it almost introduced a sense of ambiguity into the condition, almost asking a question. But I don't think we have any strong feelings. We just wanted to hear comments. It's unusual, but then it's, of course, the proposal straddles local authority boundary. But you're absolutely content with that form of words, I take it.
We are. I mean, I can see that if there was, I can't see an issue arising unless there's some dispute about whether you go to the mineral planning authority or the other planning authority. I don't anticipate that. And it may be that there's one planning authority for the whole area by the time we get there.
Ms. Dropkin Rita, or is it Ms. Terralinga?
Thank you. I was just going to say we agree with the applicant's position on that. We tend to use that wording for a number of our cross-boundary applications. So it's consistent with the approach we've taken on other projects, including a recent Transport and Works Act order application.
Thank you. Does anybody else want to make any points on that particular point? Because I think I've heard what I need to on that. Okay, the next sort of general thing is I'm conscious that the planning practice guidance sort of sets out a sequence in which it recommends conditions to be laid out. But having gone through these, I think myself and Mr. Clegg felt that it may be more helpful if conditions addressing the same subject were positioned together, so that the sort of requirements for any investigations, for example, on contamination, there's a read through between conditions that then go on to any monitoring and implementation. So that was just a sort of general comment about sort of sequencing. Are there any comments on that? What do you have a view on that, Mr. Roberts?
So I remember the day when that's how they used to be ordered. So it's completely logical to me. No objection at all.
Ms. Taralinga,
No objection from us on that.
Any other comments on that particular point? No? Okay. This possibly exposes sort of some of my ignorance of the Town and Country Planning Act in terms of pre-commencement conditions. But I think I'm right in saying, and this is where I'm obliged that we've got at least 3 barristers in the room who can four barristers, sorry, who can keep me straight. That I think I'm right in saying that because Section 90 of the Town and Country Planning Act mentions the Transport and Works Act, that that the provisions of Section 100 ZA3, I think it is, which require, or 5, I think, which require the applicant's written approval of any pre-commencement conditions applies in this case. But if any of any people who've got a much better view of the legal side would
I'm
like
sorry
to
to start off on this basis, but we take a different view.
Right, okay.
And let me explain why. Because of
Please,
the definition of what is a relevant permission in Section 100 ZA, subsection 13, paragraph A. Reference to a relevant grant of plan permission or to any grant of permission to develop land which is granted on an application made under this part. This isn't an application made under this part. Notwithstanding, Section 90 and specifically Section 90 subsection 2A is within Part 3. This is not an application made under Part 3, and therefore it's not a relevant grant of plan permission. But to remove any ambiguity, we have no problem at all. One Paul Dickinson will write to you formally in very short order to provide that confirmation in the event that you need it. So although we don't think you need it, we'll simply provide that to you in a very short letter from my instructing solicitors.
Thank you, Mr. That's why I'm grateful that we've got people who are much more familiar with the details of the Planning Act than I am. It's not a major point, but are there any other questions on that particular point? I'm grateful for the clarification. Thank you. Moving now to sorry, Mr. Clegg, you want to? Moving now to condition 1 as it's set out on the list of conditions. In some respects, a fairly standard sort of commencement condition. I think the first question was, having heard the evidence from a number of parties, particularly on the applicant side, about the sort of the need to avoid delay. The question is whether a 3-year implementation, a 3-year commencement requirement would be appropriate in light of the evidence. Mr. Roberts.
Yeah, the short answer says we'd like to stick with the 5 years, please, bearing in mind the challenge period and the potential for that to take up, frankly, up to 2 years. That is the project risk that 5 year period is seeking to deal with, and therefore we'd like to keep it at 5 years, please.
Is there anybody else who has any comments on?
Mr. Henson was about being correct me if I'm wrong, but I'd understood that if there was a statutory challenge, that the period would be extended in any event. But that may not apply. I don't know when.
Yeah, no, I've just looked at that. Section 91 is what you have in mind. But we'd have to double check that applies. I have a suspicion it doesn't. But our firm view is the one that I've set out for you already. Not the reason why I suspect it doesn't apply is because of section 92, because we need approval of reserved matters under our conditions 19, for example. We can double check that. If that's going to tip the balance, we'll come back to you on a firm view. But in any event, bottom line, 5 years is the challenge period.
And just sort of say, it's purely because of the challenge period that you're seeking 5 years. Is that?
Yes, correct. Yeah. Because I mean, our experience on that is the challenge on this sort of infrastructure project, even best one in the world, does not go away quickly.
I think it'd probably be helpful if the point Mr. Parker made. I understand your position, Mr. Henderson. Just to understand that point about the clock stopping under.
Yeah, we'll double
challenge.
check it. The point is whether section 91 subsection I think it's 3B. Yeah, 3B. Whether that assists us by extending that time for 1 year. And we will just need to double check that for the Transport and Works Act context. Because there's a different provision made in section 92. But so we will just need, and we can come back to you later today if you wish.
Might be helpful.
We just need 10 minutes over the break.
Yes.
Just to read those through and come back to you with a firm answer.
Could you just clarify why you are concerned about the reduction from 5 to 3 in terms of the challenge period and the periods of time that are involved?
Well, because to put it very bluntly, we need the challenge period to have elapsed without a successful challenge, and with the termination, i.e. the coming to an end of any challenge that might have been made unsuccessfully, in order for the project to get up and running. I mean, that's pretty typical. If we have that challenge looming over us, that is going to severely curtail what can be done to move matters forward whilst a challenge is extant. But that's the same whether I'm putting 100 homes here, whether I'm putting a busway here. If you've got that project and you've got a challenge, that is just the reality of the amount of money we're going to be spending and the need to make sure it's free from challenge before all of that cost is incurred, bearing in mind especially how we're funded in this case.
Just briefly in terms of the substance, on the law, hopefully we'll be able to give you an agreed view. But if that is the concern, then I would respectfully suggest that the wording of the condition should not be simply to extend the period by 5 years, but should be
2 5 years.
2 5 years. Sorry, 2 5 years. But obviously, in the event that there isn't a challenge, the condition as worded would still provide for 5 years. So in my submission, it'd be perfectly possible to come up with a condition worded by reference to the existence or not of any challenge, because if there isn't a challenge, then the period should be 3 years.
Thanks, Mr. Spark. I think we've heard the.
So one more point, and
Sorry.
stepping away from the
Yes.
legal points. If we're looking at this as essentially an outline plan commission with reserve matters required, the time period would ordinarily be 5 years in any case. And so from simple, well, there's very good reasons for that. So that's what I was saying.
Thank you. Moving on now to condition 2. The draft condition says the development should be carried out in accordance with the approved planning direction drawings. I think our view is it'd be much more helpful if there's actually a specified schedule of drawings, particularly because some of them have changed through the inquiry. I think the other comment was also about documents, is making sure that it's only sort of those parts of documents with which it's essential to comply, rather than providing a comprehensive list of documents, some of which may just be providing data, background, evidence, etc., rather than actually particular positions or requirements with which it's seeking to comply. So again, any comments on that?
We understand the point, sir. Our suggestion would be that you use the list of planning direction drawings, which is at Schedule 2 to the request. So that's
Schedule
C2. So it's CD 114, PDF page 24, which lists Schedule 2, and that is the list of the drawings on which this request, I should say, was made.
But is that not already out of date?
Well, I'm happy to take it away and check that we've updated
Right.
any references.
Ah.
That's absolutely fine. But in terms of the principle of how this should be approached,
Yes.
that is our suggestion. It would be that Schedule 2, subject to any updates, and we'll identify for you clearly which ones, if any, have been updated. And I think that is what is meant by the wording in the text we proposed, when it says the approved planning direction drawings. When you think, well, what are the approved planning direction drawings? Yes. It's your question. The answer is it's that Schedule 2.
Yes, so, I mean, I'm conscious that even though I think changes have been minor, that there have been sort of 1 or 2 minor changes to plans. So presumably the revision number, at least in that schedule, might have changed on a number of.
If there's been an update, yes, that's what I would anticipate. But as I say, we'll double check for you.
It's Cambourne.
No, like the point that you pointed out, sir, there was an error on one of the drawings, I remember, and that will be revised.
Sorry. Just so I'm clear, Ms. Henderson, what are you saying that? I mean, I think our view was still that an explicit reference to a schedule would be helpful.
Yes, absolutely. I'm sorry if I wasn't clear. I was trying to direct you to that to understand what was meant, but we would anticipate that would be reproduced in an updated, if necessary, form. Yeah.
And was it the intention, that it should just be plans along the lines of Schedule 2, because the heading for the conditions includes documents?
Correct, sir. It should just be in line with what you see in Schedule 2. You're not going to get bits of the DAS or anything like that.
Yeah.
Just those plans.
Is there anything anybody else would like to add to that to that point? Okay, to move on.
Yeah, that's fine.
The next one was condition 3. which is entitled the development phasing plan, and so there's a number of comments that we got about this, and I think also just wait a second. Yeah, so there's a number of comments there. I think the first thing, reading the condition, it appeared it was trying to do two things, both provide a phasing plan, but also actually sort of set out requirements for the detailed design. So I think we felt it would probably be more appropriate if there was a clear and explicit condition which would actually set out the requirement to provide the detailed design, especially given that that's been a matter that's been referred to a number of times during the inquiry. Another comment, which is something we'll probably say on a number of conditions, is what we refer to as a tailpiece. What we mean by tailpiece, for those of you unfamiliar, is at the end of the draft condition, it sets out that the development should be carried out in accordance with the approved development phasing plan, unless otherwise agreed in writing by the relevant local planning authority. And it's that bit at the end which says unless otherwise agreed in writing by the relevant planning authority that we refer to as a tailpiece. And normally that sort of requirement isn't necessary, and also can lead to uncertainty. And then there's a couple of detailed comments there about there's a reference to enabling works, but I'm not sure where enabling works are sort of set out as to what the scope the scope includes. Also, I think in conditions, including phrases like etc. is not happen in terms of precision, and that there's also reference to locations which I think are already set out on drawings. So, for example, I think there's the construction compound drawings, which they've already been sort of set out. So it's unclear why there'd be a requirement to provide those locations again, unless there's a reason. So again, perhaps Mr. Roberts, if we're going to start with the applicant for any comments on this.
Tail pieces, we're happy generally.
Okay.
I know you put that on a couple of conditions,
Yes.
but generally, yeah, take the tail pieces out.
Thank you.
I'll leave Mr. Roberts to deal with the substance of the.
Thank you.
Yeah, so I think you're correct. The purpose really is to deal with the sequencing of all of this information, and so part one, I think, is what you're referring to, where it talks about detailed design could be completely extracted. Question is, of course, is whether that's already covered in other conditions in any case. Landscaping, for instance, is already grappled with elsewhere.
Do I take Mr. Roberts, you're happy with the principle of splitting the detail?
Yeah, absolutely. So
Yeah.
no problem with that.
And in terms of phrasing of enabling works, I mean, is there a definition anyway? I'm not sure the order provides any sort of definition of what enabling works might encompass.
There is not that I'm aware of, but we'll just check that.
I suppose that the question is, you've mentioned archaeology and site investigations, and we've got suggested conditions about those. Haul roads have already been mentioned in terms of some of the evidence and site compounds. is there anything else in addition to haul roads and site compounds that might, and obviously the pre-work investigations that you consider would be sort of included in enabling works? For example, is the demolition of the Atlas building, is that considered an enabling work, or is that a different category? I know we've got a separate.
Okay, so one might include that, likewise tree removal. But I think for purposes of this condition, those are the works that we anticipate being the enabling works. But you're quite right; they are dealt with elsewhere.
And also, was there a specific reason for putting locations of proposed site compounds within there, or was the intention that the phasing plan should sort of clearly set out when site compounds would be provided, and then sort of the sites returned if they're just going to be for temporary use?
So the locations are identified on one of the approved plans or plans submitted for approval. So it's unclear why that would be needed, actually. So if we're honest about it, so really it's dealing with the sequencing of that, and then when it's required and when it's
a question of timing in terms of the compounds rather than anything else.
Yes, and so do you envisage the phasing plan, as well as setting out phases for the construction and implementation of the scheme, that it would also include when those site compounds would come on stream and when they'd expected to be completed and remediated, if they're not going to be the site for a pond or something like that?
Yes, would include that.
And just to answer that, you'll see on the second part, there's, for example, a reference to a construction program. So again, go time the time and items together. Not just the where in terms of the phase, but the when.
Yes.
Thank you. Has anybody else got any comments on that development phasing plan? Okay. Okay, so moving on to. Oh, sorry, Mr. Roberts. Yeah.
Terminology used and.
Oh, yes.
Systems and usage and margin of drawings.
Yeah. I think, particularly in conditions, it's important to sort of be precise, so that somebody looking at a condition, we've already heard about potential timescales somewhere down the line, there's no confusion as to what's actually being referred to. Thank you, Mr. Roberts. Condition 4, and really it's conditions 4, 5, 6, and there was also one towards the end of the list about the site investigations, particularly around any contamination. To deal with that in sort of two parts, I think there's some detailed comments to start with. We've used the shorthand of PIN's wording, which is it tends to be what's meant by that is the wording that perhaps planning inspectors often refer to, where we normally have a sort of a 4-condition set, which requires the risk assessment if necessary and strategy, then a remediation scheme, then a reporting process, which also deals with any unexpected contamination found. And then the long-term monitoring in response to that. So that was the first question. I think you've probably already answered the question about putting them all together as a sort of as a set, rather than having 4, 5, 6, and then 26. But there's also, in terms of the work that's already been carried out and provided to the inquiry, whether there should be an explicit reference to that, or whether there's actually a reason why the condition might want to require something different.
Just moving on from the point about the set of these topics. Using the this wording, you make absolute sense. I'm familiar with that wording and the way you structure those conditions, and it seems to me deals with the exact issues.
Okay.
So that would seem perfectly reasonable if you say that's and we prefer to structure those conditions. In terms of referencing what was.
This is the second paragraph, condition 4 you have in mind, yeah. So where it says based on, and you're asking us whether based on are the right words.
Yeah.
End of the first line.
Sorry. Yeah. 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 So that's it. Thank you. Yeah. So it was just again getting some sort of precision and clarity. Yeah. And as you rightly pointed out, with Sense, actually, I think yes, it is looking at based on. I mean, is the intention that it should accord with the work that's already done, or is it merely that it needs the work that is yet to be done should just take that into account? It's just some clarity about that.
So we'd expect it would generally be in accordance with as a phase 2, but it seems to us that the better word in here is simply to have regard to, so that all things being equal, it will simply be in accordance with. But if there's something that's being raised that's novel or not being considered, that will be captured anyway. It's not. We can't turn around and say, well, it's not in the phase 1 or it's not in that document, so we're not going to do it. So it would be fair both ways. If it's having regard to that document, we'd follow it. If there's something that needs to be added, it would be added.
Thank you, Mr. Henson. Yeah, I think yeah, making sure you're perhaps not tied to particular things if other circumstances arise. Mr. Terlinger, do you have anything you want to add to that, or?
Sorry. No, we agree with the approach that you're proposing. We don't have anything to add to that.
Thank you. You happy with the response on that?
Yes.
Any other comments on that?
Yeah, I don't think so.
Yeah. In that case, I think that's probably covered draft conditional suggested conditions 5 and 6 as well, unless there's anything that anybody wants to add on those. Moving on to archaeology, I think the first comment there was in light of the applicant's proposal to set out a phasing plan. It would appear sensible to add a reference to phases if that is what the intention is. And in terms of implementation, I think that there was sort of a question about when that was actually expected to happen. I mean, normally you'd expect the condition to sort of say that, and again, we've already talked about pre-commencement conditions, that substantive development, for want of a better word, shouldn't occur until archaeological investigations and any mitigation or recommendations have been carried out. So I think there was a phasing, the phasing question there, because at the moment I think it says it talks about where relevant for that phase. It was really just tying that in to make sure that the phasing is explicit, and probably tying it back to a revised condition 3. And the second point there was more about just making sure that we don't, well, that people aren't faced with a situation where requirements for writing up, depositing, etc., isn't a sort of something that stretches on for years after an archaeological investigation has been carried out. So I think a deadline or a limit to where anything that comes out of criterion C is provided by would be helpful.
So I think really your first 2 points about the language, the point about phasing, it's definitely got to be phased, and we've explained to you why that is, and that's fine. I think what you're trying to ask us is, should it be essentially before the commencement of development in any phase?
Yes.
If that's what we thought we'd done that, but if you don't think it's effective, we're happy to.
I think it depends how you interpret
Yeah.
secured implementation. It could just mean that a programme of implementation has been agreed but not necessarily carried out. Our concern is to make sure that the archaeological work, the investigation, is done before spades go in the ground and building a busway.
That's fine, isn't it? Yeah. Well, so I understand the point. We're fine with what you've suggested.
Thank you.
There's just one point that I would like to make on the where relevant for that phase. We do ask that those words are retained. The reason being, if you just read on in that sentence, sorry, the next sentence, the mitigation works will be required in relation to areas of archaeological significance identified from the preceding archaeological evaluation works, i.e.,
yes,
it may in a particular phase you may not actually need to do anything.
Yes.
Yeah.
So the where relevant is trying to capture that.
Is there anything else anybody would like to add to that? And in terms of the criterion C, Mr. Roberts, is there a sort of a default or standard timescale that you would that you'd recommend? I mean, I realise that if it requires publication in a journal, that can take a considerable amount of time to arrange. But I think the thing is, we just want to avoid an open-ended condition where perhaps some years after an archaeological investigation has taken place, there still hasn't been any of the required either reporting, publication, depositing of physical material, etc., and it's sort of still under the archaeologist's desk, as it were, rather than in a museum or where it should be.
I think there could be two ways to deal with this. So the condition says it's a time frame for depositing that analysis. So or we give a time frame. On other projects, 2 years springs to mind for providing that information or depositing that information. But it might well be worth, given the phasing here, simply requiring that the WSI set out time frames for depositing that information. That would seem to provide the greatest flexibility.
So just so I understand, the first option is that the condition requires the written scheme of investigation to actually specify a timescale, and then the condition would require that it needs to accord with the timescale that's provided in the WSI. Your alternative, I note your point that you prefer that first one. The alternative would be for 2 years, and in terms of that, would that be from 2 years from the completion of each phase of archaeological investigation, I'm assuming? Thank you. Are there any other comments on archaeology? In some respects, it might be helpful to take both conditions 8 and 9 together. Condition 8 seeks basically the approval of the Code of Construction Practice. We've got a draft one which has been submitted as part of the inquiry documents. And Condition 8 also provides measures for temporary measures, particularly relating to bat flight lines during construction, and a requirement to involve Natural England. Condition 9 requires a local environmental management plan, and that condition's got a lot more detailing. And I think the first question is actually, do we actually need two separate conditions which appear to be doing the same the same thing, because they both appear to be concerned with construction. It doesn't appear that condition 8 is dealing with construction, and condition 9, a local environmental management plan, is dealing with operation. So that's I guess the first question before we get into the details of it.
I think condition 9 has a lot of the detail that we'd normally expect to see in a condition entitled Code of Construction Practice. I suppose the question is, should there in effect replace, should there either be just condition 9, which will embrace the principle as well as the detail, or should there be a series of conditions in condition under replacing in effect what is condition 9, because condition 9 requires a whole series of further plans to come forward. Would it be better structured if each of these was subject to a separate condition? I just welcome your thoughts on that approach.
So I think the reason why there's firstly two conditions is one's establishing sort of the baseline, while the condition 9 then deals with the detail. And so it's the applicant's preference, and as agreed with the council, that they remain as two separate conditions. Which you're quite right, will no doubt speak to, well, we'll speak to each other, and it may well be that information is submitted together or close together.
And that brings clarity also in the context of the ES, because CD 126, you'll recall, is part of the full process behind the judgments in the ES. You recall hearing about air quality, noise, etc., all of which refer back. So condition 8 immediately captures and ties what you've seen in draft form into an approved document. So that all of that baseline, as Mr. Roberts said, has been captured in accordance with what the ES assessed. Of course, it then does go on, as he said, to give you more detail in 9, but 8 is the necessary first step so that the basis of assessment is secured before, of course, some additional measures can be approved by the local authority local authorities, I should say, under condition 9.
But on the example that you gave us, Mr. Henderson, you've got D in condition 9, which deals with air quality and requires a plan to come into the local planning authority.
Yes. And sorry, go on.
I would anticipate that the local planning authority would refer back to the ES in considering the plan.
They may well do, sir, but essentially so that it is robustly secured from our perspective.
You need 8.
We think you need 8, yeah.
But how is it robust when condition 8 simply says accord substantially?
Because that form of words...
I mean, it's very flexible.
Well, it is. I wouldn't say it's very flexible. That form of words, in the context of challenges to the adequacy of environmental statements and conditions, is pretty well established. If we have something along those lines, we can say confidently that the basis of assessment in the ES has been secured by condition using that form of words. It doesn't preclude additional matters, which is 9.
Yes.
And no one's saying that additional matters won't necessarily have to come forward as part of that process of working with the local planning authorities. But the first point, have we secured the basis of assessment of the ES in a sufficient way? We have done through condition 8. And that from our perspective is really important to de-risk that side of the equation.
So in terms of the ES and there's a mitigation schedule. I think probably the conditions listed in there probably now refer to slightly different numbers. So is the intention then that all the mitigation that's been set out within the ES that says in order to either avoid, mitigate, or compensate from effects, that would be picked up by condition 8, or is it that the specific criteria or requirements in the local environmental management plan would be the things that actually pick up those mitigation proposals? Because
Sure.
it does seem again that there is a bit of a crossover there.
I'm not saying there's no crossover there, but if I could give you an example, if we think about the air quality example which we looked at,
Yeah.
CD 11102 is the technical report, and if you look within that, sorry, I'll just give you the references unless you want
Yeah.
to turn it up. PDF page 88, which is Appendix J, and you've looked at this already, has mitigation measures for the construction phase, and you recall they are part of what the assessment's based on. And it says expressly at the top of that page, these measures are incorporated into the C2C Schemes Code of Construction Practices. That's CD 126, which you've also looked at. And so those measures which you're talking about, so they are all in that appendix, and you've looked at a number of them, and they correlate with the mitigation measures. But I'm just taking you this as an example. And therefore we've got that secured. But of course, in the air quality context, that as we work through those, the LPA may need some additional control, and that's where you get the length on that, as Mr. Roy says, on that baseline. And so when you look at the length in condition 9, you took me to D, the construction dust air quality assessment management and monitoring plan. Well, yes, that's based on what's in the COCP, but it might well have quite a bit more detail. And that's the mechanism for the local authority at that point in time. Does that make sense?
So yeah, I understand the point that you made now about condition 8 seeking the baseline, because the ES has explicitly referred to the code for.
So nobody can say later that you've let us off the hook by assessing one thing and then granting a different thing. This ties the grant to the assessment.
I suppose the question is, but couldn't you just combine that in one condition anyway?
Well, I mean, as a matter of land use, I'm sure you could, but our preference is essentially one of clarity. Condition 8, COCP, done, then you move on to condition 9. I'm not going to push back too hard, because I think you understand what the principles have to be, and if you feel it needs to be set out differently, then, we're not going to die in a ditch over how the conditions are set out. That's not a reasonable position to take, but I just want to make sure you understand why we've taken the approach we have.
That's helpful.
As it stands, condition 9 is lengthy and detailed. Would you have what are your views on separating it into different conditions for different plans, but nesting underneath condition 8?
It is long, so it's 3 pages. Agreed. So I think you've given examples, the CTMP travel plan, and so there's no objection, sir, to extracting those elements into separate conditions if that's what you would like to do.
Are there any comments about that, the general approach that anybody wants to make there? Yep, Ms. Terralinger.
I think I agree with the approach you're proposing. Splitting that condition 9 would help us actually in terms of just dealing with those matters separately. So we agree with that approach.
Thank you. Now looking at just some of the details, I think we've already dealt with the tail piece under condition 8. Just talked about their specific components, but I think that's been addressed by how Mr. Henderson has explained what the applicant considers the role of condition 8 in relation to condition 9 is. On specific wording, that in terms of back provisions, because the actual wording, I think in there includes measures for temporary hedges and screens to maintain back flight lines during constructions. Is the intention that if there are other measures that would then come out of condition 9, or was the intention that should all be covered by condition 8? It may well be again that sort of anticipating what you're going to say is that condition 8 was intended to set the baseline, and then the details would be in one of the more detailed proposals in number 9. For example, you've got the various criteria for ecology site management plans for protected species. It's under under 5O, the elevated back crossings of busway, etc.
Exactly as you put it, sir, with the detail to follow in condition 9.
We should say we have no issue with your words and any other measures that you had in mind to maintain that status.
And this another point there is just a lot. This is more to do with detailed wording. There's a number of conditions where the requirement is that there should be involvement, consultation with particular bodies. I think Natural England is the one that's been mentioned most. I think one was just trying to get consistency in wording, but also recognising that at the end of the day, the local planning authorities will be responsible for discharging the condition or not. So there's just some suggested wording there, which about how to sort of contain this, because is the intention that, as I say, the local planning authority should not approve any details until they've consulted Natural England on those proposals and taken into account anything that Natural England said. Are you after something stronger that say the local authority mustn't discharge the condition unless Natural England agrees to?
No. we certainly don't want that, sir. That this is simply meant to be that the LPA will offer Natural England the opportunity to comment. If Natural England take up that opportunity, the local authority will have regard and no more than that to what is said by Natural England. So your proposed wording is, if I might put it on the right lines, the words that we take slight issue with are at the start, where you say the local planning authority shall not approve the COCP. We think that is going a bit far. It needs to be offering Natural England the opportunity to be consulted and to provide comments which are then taken into account if any comments are provided. So with that caveat, I think there's a common understanding based on the rest of your proposed words, but it can't be a prohibition on the local authority approving it until they've definitely got something back from Natural England, because we're relying on Natural England not to hold the whole thing up, and etc.
It's not saying it's not saying that something's got to be received back. It's just saying that consultation has to have taken place. Consultation doesn't necessarily expect a response.
Okay, so so when you so the bit "and any comments made by" you mean comments if any are made?
Yes, exactly.
Okay, well we're happy with that.
Yeah.
That's
that was certainly the intention. So that if there was a circumstance where the body was consulted, nothing came back, it wouldn't prevent.
Well, that's the subject to that concern which I've ventilated. Where otherwise, in agreement, it's a consultant taken into account.
Thank you. Before we move on to any other comments under the local environmental management plan, is there anything else that anybody would like to say about condition 8? No. Okay.
Perhaps just one point to raise, and it may be arguably a condition 8 or a condition 9 point, is condition 33, which deals with construction hours. It seems logical that we've already talked about putting similar things together. If this is a control to do with construction, should it simply appear here as next in the line, or should it be incorporated as a general construction concern, perhaps in condition 8?
So this concerns construction traffic, doesn't it? I think, if I've understood your comment correctly, in terms of
construction work generally, not just traffic.
Yeah, because I think at the moment the LEMP covers both construction traffic through a construction traffic management plan, but also actual work on site as well.
So if I'd understood your comment correctly, the condition 33 deals with hours of operation, I think, in terms of construction hours.
It does, yes.
And then your comment relates to construction vehicles, i.e. delivery vehicles or muck away, things like that. So the construction vehicles attending site, that there is nothing in the consent which deals explicitly, or nothing in the conditions which seems to deal explicitly with that part, is my understanding.
Yeah.
And I would expect a construction traffic management plan to deal with that as a must, really. I accept it's not explicitly listed, though it does at A4 reference construction routing, and then it talks about hours of delivery related to school drop-off periods. Not as explicit as you might have liked, and so therefore I see no reason to not drop in that requirement that we identify.
Yes, I think our concern about condition 33 is it's a broader point,
Yeah.
not just to do with traffic, but construction activity generally,
Yeah.
specifying the hours within which it can take place. So the point is simply, should it simply be moved so it appears in a different part of the schedule? Should it perhaps be incorporated in condition 8 or sit or nest under the land?
I think there's 2 points. Is it might be that in certain areas of the site, it would not be appropriate for construction traffic to, as I say, deliveries and muck away, for example, for those movements to occur during certain hours, peak periods, because of conflict with schools and other things. In other parts of the site, of course, it might not be an issue. And so it seems right to leave that to the construction traffic management plan, to the local planning authority, in consultation with the highway authority, to make that decision, rather than explicitly setting out those times in a condition.
I think we're talking slightly different purposes.
So on that basis, if you want to move it,
yes,
fine. If you want to incorporate it, push back on that, because they're doing two slightly different things. So Mr. Roberts' point about letting the LPA deal with those site-specific matters about this particular sensitivity, that would be the construction management plan, and that could be in some areas there's absolutely no problem with deliveries early on in the morning before work commences. In other areas, there might well be a problem.
Yes.
That would be picked up by the LEMP, separate from what you have as the general point on the hours of operation in condition, forgive me, 33.
33.
Yeah. So if you want to move them so they appear together, that's no issue with that. But it seems to us they're doing slightly different things for the reasons that Mr. Roberts has explained. So we wouldn't be necessarily in favour of incorporating them into one another.
So as I understand it, what's currently in the hours of operation is an absolute. This is when construction work can and can't happen.
Yeah.
The construction travel management plan or construction transport management plan, it will be setting out much more detail in terms of traffic movements, having sort of being aware of what the absolute site operation times are in the hours of operation. Is that it? So hours of operation is the top one. Then obviously any construction travel management plan needs to fit in with that.
Yeah, so if you just turn up 33, I'm sure you have already, when it talks about construction works being limited to those core hours, say for start up and close down, they are the construction works under the order on site.
Yes.
And that we see as being slightly different to what the construction management plan that we're talking about will include some of that, of course, but it will also include other elements like the off-site deliveries, where they're going to wait, if they're going to wait anywhere, etc. Those points, which would be subject to bespoke consideration, wouldn't just be lumped within those core hours, but would be on a much more bespoke local level. And we think keep them separate for that reason, but still have both controls in place.
But moving condition 33 doesn't necessarily cause a conflict. It just sits.
No, I apologise if I wasn't clear. Move it by all means.
Yes.
Just don't incorporate them.
Understood, and I think that's addressed some of my comments about the construction hours. Is exactly that point of where you have a site, can't start work till 9 o'clock or whenever it is.
Yeah.
But then you've got lorries sitting outside people's houses and generally causing a nuisance.
Yeah.
So if I understood correctly, you're saying that's the construction transport management plan would deal with that.
Exactly.
To say that if it's in a residential area, if it's near a school, there'll be specific times. If perhaps it's away where there's less likely to be disturbance, there might be more flexibility.
Yes, we have some construction compounds which really are not near any receptors, and where early deliveries or late takeaways not going to be a problem. But there are others which are, and that just needs to be worked through with the local authorities on, in each instance, bearing in mind what is going to be phased from those construction compounds, which is of course going back to the earlier phase and condition that we talked about anyway. So if to take an example, if one construction compound is less sensitive, we might leave that open for longer through the construction programme because it can be used more, for example. All of those sorts of balancing exercises and considerations, post the detailed design in consultation with the local planning authorities, based on what the prevailing local circumstances are at that particular point in time.
Mm-hmm. It does seem that scenario where you talk about compound being left open for a longer time suggests that there could potentially be a conflict with condition 33, which sets absolute hours.
No, we don't see that necessarily. So what I mean by that is through the construction programme, so in the phasing plan, where that refers to the phasing of those compounds that we talked about earlier.
Yes.
Those sorts of, well, which compounds do we need when?
Yes.
Sort of like that. Each will have different attributes. Some will be
Of course,
closer to work.
we understand that.
So the point is that's all. We need that flexibility to work through the local authority in due course. So no conflict with it. They will work together, but it's just about dealing with that in due course, because we can turn up on site without breaching condition 33 if it's suitably controlled through the construction transport management plan.
But once activities that are taking place within the compound,
yeah,
they're controlled by 33.
They are, the construction works are, yeah.
Yes.
That's fine. But we're talking about the other aspects. So hence why we.
Well, it's a question, I suppose, of interpretation of what construction works involved.
Well, I mean, we think it's pretty clear, and the word in there is agreed with local authority based on their experience, and for example, the caveats there about startup is again agreed with local authority.
We were going to come to startup and close down, because as it's written, we're just concerned about precision with those references. How long is startup and close down? I think it gives ample room for arguments the way it's presented.
Well, I understand the point. I think our approach to this with the local plan authorities is they're fairly used to dealing with those sorts of points, and they have not just, and that's why the two conditions work together. Because just to go back to where we were a moment ago,
yes,
the requirements of the length, would include those time points about deliveries, etc., and that would be part of controlling what.
Yes, you've arguably got control there, but that's only referring back to what you've mentioned, only in relation to construction traffic management plan, and arguably other activities could take place in relation to start-up and close down.
Well, there will be other activities as part of startup. That's entirely the intention.
Yes.
I hope that is clear. I think it is clear. But you're saying, well, what is the scope of those activities?
And how are they controlled?
I'm just going back to the COCP, because I think there is. Yeah, if you look at the COCP section 3.5, so CD 126. And it's on PDF page 11. There's a section.
Excuse me.
Sorry, I'll take it slowly. What CD?
Right, it's loading now. What page?
126 PDF 11, sir. Internal 6. And you see 3.5 at the bottom of that page, start up and close down periods. I'm sorry for not taking you to this earlier.
Yes, I've got that set.
But you'll see there's actually 3 sections: 3.4 working hours, reflecting what you've seen in 33,
Yes.
3.5 start up and close down, and 3.6 additional working hours. Now, the control on precisely what goes into those startup and the close down within those 1 hour windows that are referred to in the first section of paragraph 3.5.1, that would be controlled under the COCP. So the construction program is put together. The principal contractor says, we need to do these sorts of activities during the startup.
Yeah.
Are they in my COCP? Yes, they are. They've approved by the local planning authority, so we can do them during startup. If they're not within the COCP, they're not approved for the startup period, they can't be done.
Yes, but what the COCP says in 351 is this will include but not be limited to.
I understand that, but that's because this is what you've got at this stage.
Yes.
If the concern that you have about can we make it more specific, well, we can, and the local authorities can already do that under the conditions you've just looked at by condition 8, approval of the COCP, saying can you remove the words?
Could, but there's no control coming as a result of our consideration of this proposal to within that safeguard.
Well, it's not before you, but that doesn't mean there's no control or safeguard. The safeguard is you have an outline draft COCP
Yes.
that will include these measures and gives you a good indication of that now, and you know the local authority will have to approve that document, and therefore the control is not at the tip of your pen or the Secretary of State's pen today, but is it the local planning authority to deal with the detail then, and you know that mechanism is in place.
It's potentially in place. We don't know what would happen as a result of it. In terms of the documentation we're looking at, there seems to be a fair amount of flexibility and lack of precision.
Well, there's flexibility, I accept, and the words will include but not be limited to, but that's why I go back to condition 8. It's got to be in broad accordance. So if we come up with a list of, if we just look at that list, deliveries, movement to place of work, unloaded maintenance, if we suddenly say that piling is a startup activity, the local planning authority is going to turn around under condition 8 and go, no, you're not in accordance with your draft 126, we're not going to approve that. But if we need to get into the finer detail of the movements to place of work, well, that would be controlled, would be in accordance, would be what you can expect, and therefore is appropriately captured by condition 8, 9, and then indeed 33. So I understand the concern, but respectfully, we think there's control there for the local authority at the right time to deal with all the matters with which you expressed a concern.
Yeah. Well, I think we've certainly heard the points that you've made in support of your position, Mr. Senator. We'll take those into account. Yeah.
On that particular point, is there anything that anybody else wants to contribute? Okay. I think we've already dealt with some of the comments that are written down that we've provided under condition 9. I think there was a particular reference, actually, just going back to the Code of Construction Practice, sections 4 to 13. So it's a case of why is it these seem to be covered by other things in the LEMP, but I'm presuming you're anticipating a response. You're going back to say, well, actually, this provides the baseline, and then the LEMP requirements provide the detail.
Yeah, sorry to be boring, but essentially what 4 to 13 say there is make sure your LEMP covers everything in those parts.
Yeah.
Essentially given focus.
Okay, I understand your point on that one. I think There's some comments there about linked to the phasing plan. I think we've already discussed that. That's just in terms of precision. We've already dealt with, I think, how we refer to the requirement for the local planning authority to consult with other bodies. I think in terms of the sort of specific issues there, again, I'm anticipating that in terms of detailed things about sort of noise, etc., that would be covered by one of the one of the sub strategies or plans provided under them. I think I was particularly mindful of again what Mr. Lewis was saying about that, in just recognising that actually some things on construction sites which aren't necessarily actual construction work can be quite noisy and disturbing. Just to make sure that that was covered with that. I think in terms of the sort of engine noise embankment outside the site, presumably that would be covered as you see it under the construction traffic management plan. Is that correct?
Yes, sir, but just on your specific concern that you had about reverse alarms, etc., I sent Mr. Saunders away to look at this, and the answer is Part J of the condition as drafted makes reference to the British standard, and that would require that those reversing type sensors to be looked at as part of that. So it's already within what you have before you because of the reference to the British standard. I appreciate that's not obvious on its face, but just to unpack that for you.
Thank you. And again, in terms of the sort of public inspection, I just wanted to make sure that because it was prescriptive about electronic form, just to make sure that that where it's important to local communities to be able to sort of have contact with whoever the contractor is that it wasn't just limited to an electronic.
Yes, that's fine. So if you think it should include electronic and hard copy, then that's fine by us, and we'll leave it up to agreement with the LPA precisely what goes where.
And again, it wasn't clear sort of where the actual the detail of what was going to be provided for local communities. Again, just thinking in terms of particularly sort of construction that's close to a number of receptors. Where would people get the comfort that there was going to be enough detail provided by the contractor that they could contact them sort of out of hours, or if there's a particular issue? There was, I think, some discussion about community liaison sort of representatives from particular contractors during the inquiry. It's just a case of
Sure. So, I think your specific concern is there going to be a name and a mobile telephone number that you can call in the middle of the night if something goes wrong? We're fine with that. If you want to include some word in the requires, as you say in your note, named individuals and a contact telephone number, we're happy for the LEMP to include precisely that detail.
Okay. And yeah, I think we've already dealt with the following question there. Is there anything else anybody would like to any points about construction management? Okay. Draft condition 10. I think the first thing was that the protection should also refer to hedgerows, and that I think that whether actually criterion C should actually be part of a separate condition, specifically around sort of removing trees either within Coton Orchard or the conservation area. And I think the third point was being explicit about the when tree protection measures would actually be put in place. And also whether there's a requirement for the local authority to be notified to give them the opportunity to inspect tree protection measures should they should they wish. So I think those are the 3 points about tree and hedge protection. So if there's any comments on that.
Absolutely fine for it to include hedgerows, no objection there.
And in terms of whether the method statement for veteran tree transplantation should actually be part of a separate condition rather than a tree protection condition, given that what the applicant's proposing is very different from what you'd expect a sort of British standard tree protection measures to be.
But for completeness, it's the preference that it remain in condition 10. However, we do understand the point, and given that that's highly likely to represent a phase of development in and of itself, it would seem, on the one hand, it would be dealt with under that phase, but on the other hand, it would be perfectly reasonable to deal with it as a separate condition. So no objection there. So if that's how you would prefer that to be dealt with.
And just in terms of the requirements for putting things in place.
I'm just skimming to see if it prior to commencement, naturally. You're quite right. It says to be implemented as approved, but no actual requirement for it to be. At what point? So no objection to linking that to commencement of those works or relevant works.
I mean, clearly, given the sensitivity within a root protection area, what you really want is that the first person to go on the site is whoever's going to put the protection up before anything else happens, because even sort of stripping topsoil could have an adverse effect. Okay, thank you.
And just to make clear, sir, I'm sorry for being overly cautious here. It's before commencement on that phase.
Yeah.
So right, you've got your phasing.
So I didn't pick up on the point about notifying the local planning authority that the measures are in place, and again, perfectly reasonable to include that wording if you wish, just for us to notify the relevant authority that works, the measures are in place. That's absolutely fine.
Yeah, I wasn't suggesting any necessity for approval. It just gives the local authorities an opportunity, should they wish to inspect them, before other things happen. Thank you. Is there anything else anybody wants to mention about the tree protection condition? The condition 11. I think the key question there is about I mean, this is controlling the time and the ecological impact of any removal of trees and hedgerows. The question is more about the principle of whether there should be an agreement of what's going to happen to particular sites before trees or hedgerows are removed. Obviously, if a tree is literally in the middle of where the path's going to go, there's not going to be planting on that site. But it was more around actually sort of making, should that be dependent on the landscaping scheme for that part of the phase or whatever having been approved first. Sorry, it's a loaded question. I think it should be.
So I on the one hand, I can see the point you're making, absolutely. Condition 17 does require details of which trees and hedgerows are to be retained. So naturally, there would need to be an understanding of that prior to those removals, wouldn't there? So they're going to be closely linked. However, some phases may well involve more landscape, new landscape than others. And likewise, for programming reasons, it may be necessary to remove trees in preparation for commencement. For simple practical reasons of those nesting seasons, for example, which is the purpose of the condition. So the applicant's position would be to retain that, so, as drafted. There is a requirement, of course, no commencement of development until that landscaping scheme is provided. So there is that safeguard that something will follow. And details of what's been removed and retained will need to be provided as that. So any mitigation tree or vegetation planting will be covered under that condition.
So you're saying that from your point of view, you think the requirements condition 17 effectively provide. Well, my concern is that it's the phasing. You mentioned obviously there's only certain times of the year that some of the work can be carried out. It's just again in broad terms the approach, including the ES, sets out that where trees, hedgerows, habitats can be lost, there's either going to be mitigation or compensation. It's just making sure that are the conditions structured in a way that mitigation and compensation agreed before the habitat is actually removed.
This is just about birds. It's not.
Yeah. There's two elements to it. Firstly, the purpose of condition 11 is to essentially deal with birds, nesting birds, and that has direct program implications. And so at this stage, with no program in place or contractor in place, it's essential that there is a degree of flexibility maintained. And this goes to the point of condition 1 as well, doesn't it? To ensure that it can be delivered as swiftly as possible. But the important point, and you reference the policy there, sir, is that there is mitigation and compensation, and that can be secured, and that's exactly what condition 17 does. So we need to indicate those trees to be retained and removed, and what trees and plants, vegetation, etc., will be going back to mitigate and compensate for those losses.
Well, I should just add the ordering is perhaps unfortunate here because, as Mr. Roberts has just explained, condition 17 is the important condition that deals with that. Really, what we're looking at now with 11, although it says removal of trees and hedgerows, it's actually really a subsidiary component. It's a secondary step, which is not just deal with the hard and soft landscaping, but it's simply making sure the ecologist has checked before you do the removal. That's all it's trying to do. It's not trying to do anything more than that. If you want all the extra control, see condition 17. This is just a very specific point that you need the survey by the ecologist and their sign off before you take the chainsaw to it.
Understood. Yeah, and again, just So it's really about nesting birds. Okay, well, I understand your point about that. Is there anything else anybody wants to say on that particular condition? Condition 12, the soil handling management plan. I think again it was relating back to in terms of the LEMP at condition 9. What the relationship is between this and why in particular this is sort of set out as a separate condition, although it may well be appropriate for it to be a separate condition in light of what we've discussed about condition 9, and we've already dealt with the phase of development sort of question.
Sorry, someone's.
If you don't have any comments, that's
So you're content that C in condition 9 covers things, are you?
because condition the LEMP condition includes details of agricultural land classification surveys to be undertaken, and then it also refers to inform a soil handling management plan required by condition 12. It's just again, it's possibly one or the other, or just understanding why condition 9's asking for the details of the surveys, and then condition 9 is then setting out the requirement for a plan.
As well, so 9's dealing with the survey, and then 12 details. So 9, the point under 9 could be removed, and 12 could be tweaked to include reference to survey.
Yeah. I suppose alternatively, so we've got the other plans in condition 9. That it could be dealt with that way around, but the point is that they could be combined.
Yeah. Okay. Again, just to check see if there's anybody else has got any comments on that. Moving on to condition 13. Again, just why there's a separate condition proposed about the demolition of the Atlas building, and whether or not that would not just be covered by those other criteria that we've already talked about. Because I think basically it's saying is that the requirement is for a specific demolition plan in accordance with the Code of Construction Practice to be submitted and agreed by the local planning authority. I guess the question is, do we need that condition, or is there something specific about the Atlas building, its location, that I've not really appreciated?
I mean, so we're really relaxed on this, so it might well be a locational point, but one for the local planning authorities really to explain to you, I think, on this why they want us to provide a bit more detail.
Because under condition 9, there is part J, which refers specifically to demolition.
It does. That's right. So I'll, if I may, I'll pass it down the line.
Sarah Linger, is there anything you want to add to that? Or?
I think if condition 9 deals with demolition, then I'm quite content for us to
rely on that.
Yeah.
Thank you. Just check see if there's any other comments on that. Thank you. Condition 14, which surface water drainage. I think the comments on there are again. There's just a thing about how the local planning authority is going to inform its response to that condition, which I think we've probably dealt with broadly about it. I think unless anybody wants to add anything on that, I think the key thing was about, does it need should the details or the scheme include specifications about how the scheme is going to interface with existing drainage, just bearing in mind what we've heard about sort of field drainage, to avoid any increase in flood risk, either of the scheme itself or elsewhere. A lot of the details are actually sort of the physical components of a drainage system. So the question is whether there should actually be a requirement that the drainage scheme does actually include an approach to how it's going to interface existing.
Short answer to that says we think not because of Part A,
Part A.
14A.
Criteria A seemed more sort of geared to sort of existing sort of adopted drainage where
Yeah.
runoff rates would obviously be easier to calculate rather than
Correct.
something that's a bit, you know, something like sort of field drainage or some sort of informal drainage. So, but your position is you think criterion A would pick up that issue. So is your point that actually it would pick up that issue, that actually criterion A, by getting the details of all the existing surface water, would enable whoever it is to design a scheme that takes that into account?
Yeah, we see that as part of the sequence of A, B, C. So understand what's there. A, model and consider. B, produce your drawings. C, etc. And the model that's required. Full results of the proposed drainage system modelling, inclusive of all collection, all conveyance, storage, flow control, and disposal elements, including an allowance for urban creep. So it's comprehensive in what needs to be presented, and there's enough control there for the local plan authority to say you've missed something out.
Okay, thank you. So, anything anybody else wants to add to that? I'm conscious we're going. It's almost 11:30, so I'm going to suggest we have a break now. So we'll adjourn now, and we'll resume at 11:45. Thank you. it's quarter to. It's time for the inquiry to resume. I think
Sir.
I think when we started, Mr. Burford, you might have missed the start of the session.
Yes,
but,
sir.
if other people can make comments if you want to. So
Thank you, if I may. Yes, during the course of the conversations, Mr. Saunders did say that he would move the Hall Road to the south of the construction sites. Could that be considered as a condition? Not only immediately outside my house, but also 100 or so meters to the west. And
yeah, is that what you?
I was, and also, may I talk about mitigation?
Well, in terms of
operation.
In terms of that, the question about the Hall Road, we'll pick that up after we've gone through the other conditions.
Thank you.
Yeah. What was the other point you wanted to make?
With regard to the operation and the mitigation, I believe that there's a restriction on keeping the openness of the environment. Would it be possible to have some indigenous evergreen semi-mature trees planted immediately behind our building?
So that's a specific request about the type of landscaping that would be put in a particular point. Sir. And we're shortly going to come to the landscaping conditions, so we can pick that up then.
Lovely, thank you.
But by all means, as we're having discussion, you're welcome to make any comments.
Thank you.
But first, I'll go to go to condition 15 next, which is just about biodiversity net gain. And it was really about, in terms of what we've heard about that, I think the way the condition is written is about phasing, but it's really about should the overall BNG measures for the whole scheme not be approved first, and then the details in phases?
Yes, so this needs a bit of a rethink. We accept that for the reason you identify, and also because as it's drafted at the minute, it almost appears to insist on 10% in each phase, which is not right. So we can capture both of those difficulties by essentially adopting the approach that you have set out, which we had in mind, words along the lines of an overall BNG plan would be secured pre-commencement, as you suggest. It might have to be pre-commencement subject to conditions 4 and 7, as it is already drafted, because they are the site investigation. Let us understand what a bit more about the sites. Get that secured, and then on a phased basis, not making reference to any particular percentage, let the detail come forward. So you secured your at least 10% overall at that early stage, as you suggested, and then each phase would come forward within that scheme that's been set out. So that's a rewrite. You probably need us to do the rewriting, and then Mr. Roberts will do that for you if that's something that would assist. But essentially, we agree for the reasons I've just set out.
Okay, and I think there was also, in terms of monitoring, again, just an understanding that obviously it says the plan will be implemented, full, managed and monitored in accordance with the approved details, monitoring data, etc. It was just about an action that, in terms of the monitoring, at the moment, there's nothing to say that if the monitoring shows up something in particular, that anything will happen.
Yes, understood. My only slight caveat on that is whether you are going above and beyond a proper policy basis for requiring that degree of monitoring. We understand the concern. It might be something that, on a little bit of reflection, when we do the rewrite of this, we can probably incorporate anyway. But if we can just take that point away, and we'll let you know at the same time as the condition comes in, because just for example, looking through 7A, Schedule 7A to the 1990 Act doesn't apply, but as an approach, you would have your plan under that, and we wouldn't necessarily get into the level of detail even under that statutory mechanism that you're suggesting here. So,
well, no, I think it's more general than that. In terms of the condition requires monitoring.
Yes.
You're going to submit the monitoring data to the LPA.
Yes.
You are going to speak to National England, and they'll be monitoring it to periods and intervals. But what's the point of monitoring?
Yes.
If you're not going to do anything about the results?
Well, the monitoring is to understand the success of the measures. But if I was, if you look, for example, at paragraph 14 of Schedule 7A, which is the biodiversity game plan when you're in the statutory regime, none of those matters require you to get into remedial steps. Now, it might be, and I say we'll take it away, it might be that we're happy to just go with it on a slightly enhanced basis, as you're suggesting. I can't commit to that right now, but when we come back to you with the rewrite, we will clearly indicate whether that's acceptable or not.
As a broad approach, when monitoring is undertaken, it's either going to show that things are going on as intended.
It is, yeah.
Or perhaps they're not.
Yeah.
And if they're not, that suggests that remedial action is needed.
I understand the point, yeah. And as I say, we'll take that away and give you a clear answer.
So, in some respects, I'm happy to see a redraft of that, but when could we?
Oh, well, Mr. Roberts will be on it as soon as we get through this session, sir. I mean, we have in mind that we get that back to you today. We don't want anything hanging over before tomorrow.
No. Thank you. Is there anything else anybody wants to say on that condition 15? Condition 16, sustainability and carbon management. Again, I think the just question here is it appropriate to link to each phase rather than overall? And there's just a simple question about reference to grey water and why that was in there. So is that to do with park and ride facilities? The key thing is sustainability and carbon management, because you've got it in phases there. Shouldn't the plan be provided overall, and then the details linked to each phase?
Yeah, so we can see the logic there, but I'm not sure it's a bit different to the BNG point where we need to hit that 10% at least overall. The policy basis, and I'm just skipping down to and if the local plan authority take a different view, they can say, but as we understand the policy basis and the reason they are about specific measures, and indeed you see this at A through to F, and about specific measures for what you're doing. It's not the case where you've got to hit an overall carbon target or anything like that in respect to the scheme. So actually this, we say, is more appropriate on a phase-by-phase basis, because you bring forward your phase for, let's say, Scotland Farm, which is one of the areas where this is most relevant, and you're going to have to make sure that your plan deals with A through to F for Scotland Farm. And then we can do that, discharge the condition, and then move forward with the project. We don't need to link this back to other phases like you would on the BMG with an overall at least 10% position. So there's a difference in our view, but if the local plan authorities see it differently, we'll obviously listen to that.
Okay, is there anything else anybody wants to add to that? I've heard what you said, and understand the position. I think it was just as much about whether by doing it in phases without an overall carbon management strategy, it'd be a bit fragmented. But I'll take your comments into account. In terms of grey water, again, I'm just trying to think where is grey water going to be generated on the scheme?
Without Mr. Saunders popping up, I think you're right on. As the
It's just-
parking line.
okay. Thank you. Landscaping. Again, the question here is again, rather than bringing forward strategies in or parts in phases, is that the condition at the moment, unless I'm misread, doesn't seem to allow for an overall sort of strategy, which could then be produced in phases. And again, particularly given that I think condition 17 is going to cover pretty well most of the ecological mitigation and compensation. I think that's quite important.
Understand the point, sir. We're not sure it is necessary for two reasons. The first reason is if you look at on condition 17 at the second paragraph beginning, the hard and soft landscaping scheme shall accord substantially with the landscape mitigation as shown on the deemed planning drawings, and those deemed planning drawings are before you and do present the overall picture. So we say that's already, you've already got there the overall picture. And secondly, because on your specific concern about making sure the compensation works across the piece, that's already been dealt with by the proposed revision that you suggest, and we accept to condition 15, the BNG. So we don't think you need to go any further than what you've already got.
I just recall when we were talking, particularly around what was shown on the drawings, that actually it is sort of quite indicative.
Yes.
And it's sort of a bit vague in some areas about what's actually going to be there. So I think it was that just relying on sort of, it says mitigation as shown on the deemed planning drawings. I was a bit concerned whether that actually does show enough information, which is why the question was about an overall approach, because obviously we need to look particularly in the sort of habitat effect across the whole piece, even if then particular phases would be brought forward.
Well, so I understand the point, but and I understand that what you have before you is high level, we how I would characterise it. But if we were to take it to, if you want something in between the phase by phase and the detail, and the high level plans that you have before you, we don't really see there being much room to have an intermediate step. What would we include in your suggested overall plan that you don't have either already or in a detailed plan? Do you see what I mean? There doesn't seem to us to be much space between the two extremes to fit an intermediate step in. And just on your habitats, totally understand the overall point, but that is accounted for through the BNG condition and the overall provision, which will make for in that will, with the metric, deal with all the habitats across the scheme at the same time.
Is there anything anybody else would want to add to that? And I think again this goes back to what we talked about at the start, is actually incorporating the implementation as part of the condition rather than having it as a separate one, which I think we've already
fine
agreed on that. Condition 18, bat monitoring. Again, this is this issue about remedial actions based on monitoring. So the I think it's the same point we've probably already covered on the BNG.
Well, I mean, we are perfectly happy to be a bit more flexible on this, but our response to it is that it's going to all be within the strategy that is approved anyway.
So what you're saying is that the strategy,
because if you look,
would include the provision for carrying out remedial measures identified as a result of the monitoring.
Yes, sir. And if I can direct you to 18 sub F.
Yeah.
The parties responsible for any remedial measures that are required.
Yeah, but that's just identifying who's responsible. It's not telling them they have to do it.
Well, okay, we read that slightly differently. As in, if you identify who's responsible for it, then they've got to do it. I mean, our simple suggestion would be, if you think that something more is needed, the answer is to amend 18F to add that little bit more. Yeah. But we don't object to the principle.
Thank you. Is there anything else anybody wants to add to that? Okay. In there, we've this just goes back to the point we made at the start about the condition 3 for the phasing plan, and I think this was more about that we thought it probably would be appropriate to actually require the detailed design. I think you came back to said that you felt the detailed design was already covered in a number of other conditions. It's just that condition 3 seemed to be about phasing. There did seem to be a gap about where is actually the detailed design of the whole scheme going to be provided.
Understood. We see it, I think you understand our perspective on it. We see it as being in 19, 20, 21, 22 in particular. We see those being the conditions. I mean, do you have in mind, for example, a more traditional kind of reserve matters type condition? Is that what you?
Yeah, in effect, I think throughout the inquiry, the applicant has relied quite a lot about saying, well, we'll deal with that at the detailed design stage.
Yeah.
It's just because of the way that the detailed conditions have been set out. Are there going to be aspects that might not be picked up by those specific conditions? Is there a danger because they're done in sort of subjects that the overall picture in terms of the detailed designs going, there could be gaps in there.
Sorry.
So we take the view that the suite you have in 19 to 25 wouldn't omit anything. However, I recognise the concern, and I also recognise the opportunity to perhaps provide some simplification so that you can have that confidence. Mr. Roberts, once we get out of this, will provide to you an alternative more in line with a traditional RM type condition, seeking without going into too long a condition, which is the other issue, I should say, is if we try to incorporate 19 through to 25 into one condition, it's going to get quite long. But with that caveat, he will have a best stab at giving to you a much more traditional reserve matters type condition on a phased basis, like you see here, and see what you think about it. Can we leave it at that?
Well, I've heard what you could say.
Yeah.
I'm happy to have a look at a suggested condition. The comment under that, I think, is referring back to the point that we've already made on the condition 3. I think.
Yes, you've got our answers on that, sir.
So, I think the next condition was the one about the details of the busway and associated structures. I think we've already dealt with the comment about how we deal with consultation, because this is quite sort of detailed in terms of the criteria. The first one is there probably should be one for enclosures, fences, gates, etc. As I understand it.
Yes, that's fine.
Yeah. Just particularly it's specifically talking about concrete and steel finishes. I was just wondering why it was specific about those materials.
One for the local planning authorities to explain, sir.
And whether there's other materials.
Those particular elements were of concern to our urban design officers. I appreciate there's probably other elements that could have been included in that list, but those particular points were highlighted. But we're happy for you to modify that in a way that encompasses all the elements, I think.
Was there a specific concern from your urban design officer to do with sort of performance of existing schemes or something with those materials? Do you know? Or?
No, it was just to be able to make sure that we were satisfied with those particular finishes.
Okay, thank you. And I think the overall thing at the end, there's talks about sort of benchmarks, 3D modeling, definitions of key design variables, which I wasn't quite sure what they were. I think that was a bit sort of vague in terms of what 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 you're actually being asked to do. Again, I don't know whether that's come from just looking at some of the language, whether that's come from your urban design officer.
I believe it did. Again, we're more than happy for the inspectors to come up with wording that encompasses essentially all elements that relate to detailed design that could maybe simplify matters for our officers when they start to review those conditions when they come in, if they should come in.
And the second part of the question is actually, is what the council's looking for? Is it about sort of setting out some sort of design benchmarks with which the scheme needs to accord, such as a design guide or some sort of code, to cover that? Is that what's being sought there, or have I got the wrong end of the stick?
Just bear with me one moment. There isn't a specific design guide that we had there. There were considerations about potentially having a review, a design review panel that could review these details. But I have to say there isn't a specific benchmark that we have or a design guide that I can refer to.
In terms of design, I was wondering whether the condition should actually require one, so there is something to provide consistency in terms of design across the piece, which could also pick up on the particular concerns about materials.
I think that would probably assist us better than the current wording, certainly.
And I don't know if you're able to help me on that specific thing about what definitions of key design variables actually means.
I would have to go back to our officers and confirm that. I'm afraid I can't tell you what that means.
I thought that might have come from your urban designer. Yes.
So from our perspective, I mean, we agree with you about the lack of precision of those terms. We do, however, push back on the idea that we need a design guide or design code for this. Because when one just steps back and looks through 19A through to E, we're talking about, for example, about 6 bus stops. We're talking about specific overbridge. We're talking about some specific structures around the Bin Brook. These are actually not plentiful in amount. This is not like we're putting bus stops all the way around Cambridge, and we just think it's overkill when you've got a small number of discrete items to need a design guide, much less a design code, to be submitted and approved before you get going. When in actual fact, to take the bus stops will naturally be fairly similar, location sensitive, of course. But the other points, the structures, they've all got to be designed for their context. So the context of being at the end of the rifle range track, the context of being by the M11, the context of being near Coating, the context of being in Cambourne. And we just don't think an extra layer of a design code or guide is going to be that useful in that context.
Okay, thank you. Has anyone else got any comments on that? And the other question, which I think the local authority have already mentioned, was about anything going beyond to ensure good design. And I think it's possibly thinking about the scheme as a whole rather than individual features. And I'm conscious that the proposed design is distinct from the existing busways, which are the sort of the channel design. This is more a carriageway. Is there something in terms of ensuring good design that needs to be gone into? I mean, obviously, should the council decide to do something with peer review, that they can do that. It's
Yes.
a case of whether there should be a requirement as part of the.
No, it's a fairly firm no from us on that, sir. We think that's a matter for the local authority. When we present them with the details, if they turn around, as you say, and say, well, we'd like to go to a review panel, well, we can talk to them about a review panel, whether it's appropriate for what's been submitted at that point in time. It's not necessary, nor we say justified at this point in time to say, for example, it must go through a review panel at least twice, etc., etc. That's not appropriate for this sort of scheme. It's not justified. And in fairness, I don't think that's what the local plan authority is suggesting either. I think what they're saying is a tool in our toolbox. We might use it at the relevant point in time when we get there, and we're happy to just simply leave it to that. It's not necessary now.
And just going back to the local authority, is that correct that you're saying that that's one of the things you may choose to do rather than you wanting to see that as a requirement?
Yeah, I don't think it necessarily needs to be explicitly set out in the condition. We potentially may consider taking it through to a review panel. We have a few, but that's not necessarily something that we'd need to have condition.
Thank you. Is there anything else on condition 19? Condition 20, location, design, layout of access. The question there was more about whether there should be any distinction between temporary access and permanent features, and or whether that's sufficient. The second question, and it picks up something that Mr. Burford mentioned, was actually is there duplication in requiring the temporary haul roads and access to compounds under this condition if it's already covered under a different condition?
So I think there's no objection should you feel that it's necessary to split temporary and permanent access points, details thereof. We're comfortable though with it being in a single condition. Think it's clear enough, but I'll leave that point to you, sir.
And I'll just ask Mr. Burford, the condition which I'm conscious you haven't got in front of you. The way the conditions, it's not it doesn't specify. It doesn't say that haul roads must be put in this location. What it requires is that it requires the council to approve the location, design, and layout that's proposed by the applicant of a series of things, including temporary haul road access to compounds. So, as I understand it, you're asking for something more prescriptive in relation to your property. Is that
yes, sir? To me, Mr. Saunders did offer that the construction site, on the construction site, the haul road would be moved as far south as possible, or to the southern point of the construction site. And I believe at the time he was referring to immediately outside my property, or the width of my property. And I would like that extended really for 100 metres to the west. So it's specifically on that construction site, the construction traffic is to the south of the site from 100 metres through to my property.
So the issue that we need to consider here is whether that needs to be set out as a specific requirement, or whether there's enough confidence that when the applicant comes to provide the details to the council of haul roads, they will take consideration of that. I'll ask the applicant first if they've got any comments on that.
Only to say, sir, we don't think it's appropriate to pin down those exact details through the drafting of planning conditions. There are safeguards in the planning conditions which require us to provide details, and of course the conversation can continue to see if that whole road can shift, but I don't think it's appropriate to do it in this drafting and be too explicit. It'll remove flexibility for all parties. So.
Ms. Burford.
So I feel if there's confidence to that degree, there's no reason why it shouldn't be a planning condition. If it's confident that the local planning department will accommodate me, if you like, what is the problem with it being a planning condition?
Okay, well, I've heard what you'd like to see.
Yeah, we just reiterate that's a level of technical design and construction management that you cannot pin down now. You understand what we'll try to do. You understand the framework of conditions 8, 9, 3, which I've talked you through at least twice already, and I won't repeat. That is all you need at this stage, and that is the control that's required.
It's probably an appropriate point to pick up the other point I think you made, Mr. Burford. I don't want to sort of second guess what the applicant's point is, but I think what you were wanting was a particular specification for landscaping in
view of the proximity of the busway to my property, and the fact that according to the papers deposited, I could potentially have 320 bus journeys going past my property, and all that's indicated is common hawthorn and dogwood, I believe, both of which are deciduous, and I would like an indigenous evergreen planting of some kind, preferably sort of semi-mature trees between the route and my property.
So again, I'll ask the applicant if they've got any comments on that, and particularly how, when you come to prepare details, whether and how you would sort of engage with the communities in terms of how you specify the detailed design of any landscaping.
So it's a similar point to the previous one, really, that to pin down that particular requirement in a planning condition at this stage before the detailed design is commenced would in our view be unreasonable. Clearly, though, there is condition 17 which deals with the detail of landscaping, and the applicant is happy to review that with respect of Mr. Burford's property and see what can be done to bolster that landscaping. But as I say, to pin that down in the condition will remove flexibility for all parties. In terms of consultation, I am sure that is something that we can continue that discussion with Mr. Burford.
Okay, thank you. Again, I've heard the two sides of that description, and there are some more chairs if you'd like to sit down.
Mr. Underwood, sorry, could I just come in on the point about the consultation, which a number of people sort of raised a concern with me. Obviously, when the detailed designs are submitted to the local authority for approval, there's an opportunity for the public to engage at that point, but often that's not made easily available, and often those conditions go unseen by the community because they're approved by officers. And we did wonder whether there could be some wording in the conditions that, as part of the development of the plans, that there was a requirement to consult with affected landowners and other key stakeholders, so that there was a requirement for them to contact us and say, this is what we're proposing to do, so that there is a dialogue process built into that.
I mean, it's certainly not a usual thing for a planning condition to sort of dictate the arrangements that a local planning authority might undertake in terms of how they deal with conditions. And I'm not sure I've come across that before. But well, I'll ask the local planning authority what their approach is on that.
I think so. You're correct. We would not normally consult on conditions because as part of the planning approval, we would have undertaken an extensive consultation process, as has been done through this particular application. So that's not something that we have done before.
And in terms of the applicant, I mean, obviously we're talking about the particular planning processes here. What if the Secretary of State were to grant approval? What sort of beyond the planning scope would the applicant be proposing to do in terms of engagement with communities on details as they develop?
Sir, I might to turn to my client on this one.
Yes, so we would certainly be looking to engage with.
You can probably sit down with
Okay.
that if you want, rather than
That's fine. That's fine. We'd be looking certainly to engage with the communities along the route. We have met consistently with, for example, parish councils on a regular basis throughout. That would certainly continue. Therefore, there will be engagement, and certainly in particular locations such as Mr. Burford, where there's been a clearly identified request, we would be looking to engage early and make sure issues were picked up. And I think we've tried to explain to Mr. Burford the process we'd go through in terms of things like dust management plans, and we would ensure that there'd been sort of due engagement with, particularly in his instance, his household as we develop documents like that.
What in terms of Mr. Littlewood's point there about how communities might influence the details? Obviously, I accept that they don't want to see the scheme, but if the Secretary of State did make the decision to grant it, would that process sort of extend in the way I think Mr. Littlewood was suggesting?
It's difficult to work out what sort of details he is looking to. So a lot of the scheme will, as we've been explaining to his party, be based around design guidance and following that. Where there is specific things like planting, I think we'd be producing landscape plans, which we'd take to the local authority. We'd look to them if they wanted to consult on those more widely. Whether we go into detail about planting mixes, obviously, for example, where we go through his land, I'm sure we'd be engaging with as a landowner with how we would deal with boundary treatments, as we have started doing already in terms of practical things like access points and gates. Then, in terms of what would happen within his land, we'd certainly be receptive to discussions around that.
Mr. Littlewood, is there a particular reason why you're suggesting it should be an explicit requirement of a condition on any deemed planning permission?
Our previous experience on other developments is that there's a tendency for the applicant or the developer to develop the plan, submit them to the local authority, and then they're approved. And the first time the community knows that they've been approved is after the event, at which point it becomes difficult or impossible to change them. We have had some arrangements with the local planning authority before on schemes where they have notified us, for example, that a condition application has been submitted so that we can comment on it, but often the public's completely unaware that it's even been submitted. So just some transparency in the process. I'm happy to sort of take Joe on his word that they will engage with stakeholders, but I'm just basing that on some previous experience that we've had with the Great Commission.
Is a planning condition just actually trying to deal with a different issue in terms of how the applicant consults and how the local planning authority decides to do things, rather than actually what should be in or not within a legal planning condition?
Potentially, I just wanted to raise it with you. Thank you.
If I could add, so Mr. Littlewood already sits on 2 working groups where we tend to run plans past. So as has been the case consistently for the last 6 or 7 years, he would get advance notice, for example, as a member of that group, and a number of other interested groups also sit on those. So I think this is very different, perhaps from a small housing development that would perhaps go through with on-officer recommendation with little debate. I'm sure discharge conditions will be a subject of some consideration. But that's more for
Thank you. Mr. Smith.
So may I just say that my lack of confidence is due because the only reason I'm here is because I contacted the GCP in June, trying to sort out the mitigation, and the only reason that there's my house has been on the radar at all is because I have had to divulge my wife's condition, and I've had to spend time here. And frankly, I don't have the confidence, and that's why I've asked for it to be a planning condition.
Thank you, Mr. Murphy. Thank you. Are there any other points? I know that's obviously we're hearing both sides of the argument, Mr. Murphy. We're not going to give a view on that, but just check. I think that's dealt with the two specific points you wanted to raise, wasn't it? Yeah. Just moving on to condition 21, lighting. Again, it's just the point that again, a lighting scheme's been carefully considered, implemented. Should there be something to say, well, you can't just go and change all the lighting and therefore have a different effect on wildlife, etc., after the event?
Yes, sir. But that's certainly the intention of the condition in the last sentence. Carry out believed as a case of we need to strengthen that.
Thank you for that. Any other comments on the lighting? The next one is Scotland Farm Travel Hub. You possibly partly answered this, but we've just wondered why this is a separate condition for all those details.
There's an awful lot to capture there, sir, and as has been set out in evidence, it's that one part of the site where there is some extensive ancillary works to support the busway. So it's been felt by the authority and the applicant that a separate condition is needed for that.
So you're saying that you construct as a separate condition mainly in terms of administrative sort of containment and simplicity, or
it provides total clarity, yes, sir.
But if we went for a more general approach in terms of detailed design, that swept up everything.
Yeah.
There would be no need.
Yeah.
Thank you. Anything in particular about the details of the Scotland Farm Hub? Thank you. Just a detail point on the requirement for electrical vehicle charge points. I think it was just because I'm sort of guessing at what the intention of the condition is, and I think the first thing is whether the last requirement should include that chargers are available for use rather than just being installed, and also the point about maintenance and modified. Is that basically related? Is that to make sure that over time, in terms of maintenance, obviously somebody comes and fixes them if they break down, but in terms of modification, is that basically to make sure that they're upgraded as and if necessary, or just so I understand that?
That would certainly be the case, sir. Yes.
And also, you've already specified the British standard. Should that requirement about modification be linked to the British standard? This isn't an area of my expertise, so I don't know exactly what the British standard says about EV charging. But if the intention is to make sure that the provision is kept in step with developments, so that you don't end up with EV chargers that after so many years are no longer compatible with current vehicles or whatever, if I've understood that correctly.
There's a question, actually, sir, I suppose, as to whether or not the modification of charge points put in place prior to use commencing requires permission in any case. So perhaps that doesn't really belong in the condition anyway. And then on C, it's charge infrastructure, so that's not just what lies above ground. I would say, but I'm not too familiar with that VS either, I'm afraid, sir.
It's more as a matter of principle, though. So, should a condition be doing anything more than requiring compliance with the existing British standard? I mean, we would say no. And that British standard, we haven't put the detail of it before you, but the indication there is clearly future proofing, to use a slightly easier word. But is it reasonable, justified, or necessary, or any of the tests met? If you were to impose any broader hurdle on us, we'd say no, they're definitely not.
So are you saying that actually just by saying it's got the accord with the British standard, that it's actually inbuilt with the accordance with the British standard, that they would be upgraded as necessary in future?
No, it's not that they necessarily would be, but it's what is installed would be, as it says there, designed to allow for the future installation. So it's not saying that we definitely go on and do that future installation, but that we haven't precluded that at a later stage. And if you want to go any further than the future standard, we would say that would fail all the tests for a condition.
No, I was just trying to work out exactly what you wanted to do with that thing about sort of.
It's like adaptation, the ability to do it, whether we do it or not is a separate question.
Yeah. Thank you. That's understood. Anything else about electric vehicle charging? Again, I think we probably already covered this with the previous answers. I suppose the only other question is going back to number 19, whether CCTV should be required for the whole scheme. But in some respects, as I said, I think I've already got the sort of overall view of those requirements about Scotland Farm. So that probably also covers 25 and 26, I think, in terms of your earlier comments there. Unless you want to add anything. Okay. On condition 27, which is about the replacement open space land. One, obviously, it's already shown on the drawings. This condition is a bit more general, so should it not just refer to the proposed land rather than an area of replacement open space?
I've specifically identified the plots concerned.
Yes, yeah. I don't think no one said no. I mean, from our side, that seems perfectly reasonable.
Yeah. And the other thing is just in terms of when that's provided. Should that open space not be provided before the existing open space is lost?
I can understand the principle behind that, sir. The point here is about the phasing and the scope of the timeline, I should say, rather, of the construction process. And would that not be covered in any event by condition 25? Because the final part of 27 cross refers to the maintenance and management in accordance with 25, and
it's more the timescale of the implementation.
No, I understand the point about the implementation, but I'm just saying, is that not covered by 25 anyway? Because that includes, I suppose, it's maintenance schedules rather than implementation. But I mean, we understand the principle. It's simply whether that's feasible from a technical perspective. I'm not sure we're actually in a position today to say that it would or it wouldn't be. And the better approach, we say, in that regard is to leave it to the phasing, because if you recall, the phasing requires sequence to be agreed. So if we split the open space across two different phases, the LPA can say, well, hang on a minute, you're removing let's say we work, I'm not saying we will, but hypothetically, if we work east to west and we were to remove before replacing, the LPA would say at the point of phasing, well, why have you done that? And if we've got a good technical reason, the LPA can have regard to that and consider whether it's appropriate. If we can't come up with a good technical reason, they'll refuse the phasing plan and make us do it in a different order. But that's not for today. You've got a control over that through the phasing mechanism, having regard to all the detailed design and the construction process, and that in our submission is the better approach.
So just so I'm clear, what you're saying is that you would expect the phasing plan to provide an explicit implementation timescale for the open space, and then the provision of open space would need to be provided in accordance with that phasing strategy. Is that the approach?
If you just go back to 3 as it is now, the detailed phasing plan must include a proposed sequence for providing detailed design of the following elements. That includes the landscaping. And then it also needs to identify, as we've talked about earlier, the construction programme providing the sequence and timing of the proposed development. Well, the construction programme providing the sequence and timing includes when are you going to remove the existing open space? When are you going to implement the replacement open space? So that is captured because we're going to have to show the programme which will have precisely those 2 events in.
I understand your approach. Also, just given the proposed configuration and size of the Section 19 replacement open space rather than the more general plan compliance, I think even though you've got a construction compound there, could that not, just because it's a relatively discrete site, could that not be provided early on?
We're in a position today to say to you one way or the other whether it could or it couldn't, because that goes to working up the construction detail, getting the contractor on board, speaking to the contractor about the best way to do it, and balancing that, I should say, so balancing that against a whole series of other considerations. So, for example, it might be, well, yes, we could do it in the way you just suggested, but the flip side of that is we're going to have more HGVs running on different roads that would be less suitable. And so the question for the LPA then is to balance it in the round to say, well, if we reduce the impact from noise, the construction programme has to change. And the consequence of that is it's in a different order on the sequence in the open space. But we can't give you, and you can't determine that one way or the other today. That's a level of detail that the LPA will have to consider on a balanced, holistic judgment across all the different components of the construction programme.
But that's because of where you're putting it and where you're proposing to put a construction compound, isn't it?
Well, that's one of the reasons, sir. But it's more of a general point. We're running on a linear route, which we have to work, and will be worked in a phased but linear fashion, and therefore it's simply part of the detail that would have to be worked up in due course.
Okay, thank you. Are there any other comments, Ms. Littlewood?
I'm not sure it's the right to raise it, but obviously we've made the point that if you were minded not to approve the maintenance and access track, there wouldn't be access to the public open space, and you might need to use CPPS lands instead. And so the condition here refers specifically to the location put forward by the applicant, and we didn't know whether that should be left more open or whether, if you did agree with us, the condition would require to be amended. I just wish to raise that point.
Okay, so we asked the question about making the condition more specific, but you're saying, in your view, the condition should be more open without specifying a location.
Yeah.
Okay. Okay, thank you. Anything else on a replacement open space? Okay. Busway traffic signage and road marking scheme. Number of comments there. I suppose that not necessarily in order. Just traffic signage and road marking. Why do we need to approve this as part of this order scheme? Is it is it a safety thing? Is it a design and appearance? And is it not already covered by other legislation?
It's So it's set out in the reason of the condition that it is for the safe and efficient operation of the busway. So it is on those grounds.
But is there a sort of a gap in sort of legislation that would mean that without a condition on the Dean Planning Permission, there'd be a concern that the signage and markings necessary for a safe operation of the busway wouldn't happen, or is it because there's already reference to the traffic signs manual. Now, I realise that's not prescriptive. That's telling you telling you the sort of signs you can use. It's not saying that you have to use them in specific locations, as I understand it. But I just show you. Is this not covered by the legislation, effectively?
So I might have to defer to the local authority on this one. What I would say though is, obviously, part of the route lies on existing highway, which has its own controls over signage, and part of it does not. And whether or not that therefore doesn't get captured by the same requirements, as I say, I'll have to defer to the authority on this one, I'm afraid.
So it was just a safeguard for us. We are obviously not the highway authority, but we just wanted to make sure that there was something within the conditions that refer to that. But if it is covered by other legislation, we'll be for that to be.
But your point of view is you're saying this is covered by other legislation, so that's why you want the condition. Is that?
Our point is it's a safeguard in case it's not covered elsewhere within legislation that covers the order. We're quite happy to revert to your decision on that.
Ms. Carolinga, do you know what the position is with regard to the existing busways? Whether there are other requirements that have been able to secure the necessary signage there?
I would have to go back and take a look, I'm
Okay.
afraid.
Okay. And the other point is, and again, I'm not that familiar with the DFT's traffic signs manual. From what we've heard earlier in the inquiry about optical guidance, I'm just broadly aware that sometimes optical guidance requires things painted on roads. I don't know if that's proposed in this case or not. Is there a risk that is that covered for in the manual? The issue is just don't want to inadvertently say it's got to accord with the manual and then find that because of the specific requirements of the scheme you're proposing, it needs something different, like dotted lines down the middle of the road or something. I don't know.
So I'm advised that it'd be unlikely that the optical guidance would be needed. However, if it was, it would need approval from the LPA, and that's why it's captured in the condition.
So, sorry, when you say optical guidance wouldn't be needed, do you mean it wouldn't need road markings?
That's right, because the technology's gone beyond that. So,
because just to clarify, because obviously we've heard through the inquiry that it is going to be obviously guided. But thank you for clarifying.
just a moment. So, just a moment. So,
I think the phrase we've used is technology guidance. So they've moved beyond a pure optical guidance scheme that will be dependent on double white lines. But as my colleague has said, there is allowance within the condition that should we end up with a technology which does need such lines, then there is provision to seek local authority approval for the provision of those, being those would be on an asset rather than on adopted highway. So they're not subject to the normal requirements of an adopted highway.
Okay, so it is picking up that point that the changes on the adopted highway are covered by existing legislation, but the off-route ones aren't. Is that?
I think that the condition allows for us to seek approval, for example, for provided of dash white lines in the instance, which I'm not particularly anticipating that we would need to do that.
Okay, thank you. Mr. Little.
Yes, we actually support the condition in here for the same reason as the LPA, because signage isn't necessarily statutory, so there is some flexibility about what can be used. And the condition refers to historic England streets rule, which we very much support, but that only applies in conservation areas. And so there are, as we've heard from this inquiry, some sensitive locations on this route. For example, next to Coton Orchard, and for example, at the top of Long Road, where we wouldn't want to see some fairly intrusive urban style highway signage going in, and we would want the applicant to produce some signage which was appropriate to those sensitive locations. So we'd suggested potential addition to the condition which says attention must be given to signage appropriate to sensitive landscape character, such as adjacent to Coton Orchard, land covered by National Trust covenants in the junction with Long Road. Way too much. Yeah.
And are you saying that because that wouldn't be covered in either the manual, because the historic England street, I'm guessing that would probably apply mainly to the little bit at the end of which is in the Grange Restoration.
Exactly, that's my point.
Mr. Little, could you just read out your suggestion again a little more slowly?
Sorry. Attention must be given to signage appropriate to sensitive landscape character.
Hang on, sensitive.
Such as adjacent to Coton Orchard, land covered by National Trust.
You're going too fast.
Yeah, I've got sensitive landscape character, and then we're giving examples of locations.
Yeah, and such as adjacent to Coton Orchard.
Adjacent Coton.
Yeah, land covered by National Trust covenants. And also the junction with Long Road.
Thank you.
So just briefly on that, I just return to the purpose of the condition, and it's safe and convenient access of the highway, and not landscape, visual, heritage reasons. And so we say so that the condition should reflect that requirement and not be as prescriptive as suggested.
Okay, thank you. Just again, just a brief one about Scotland Farm Travel Hub. Again, it requires compliance with the traffic signs manual. Just a question that, from having seen other park and ride places, they tend to have some sort of branding type signage and things as well. I suppose two questions: does it have to comply with those, and also would it not be covered by the advertisement regs in any event?
And the third one, can you not combine it with the previous conditions? Just have one condition on signage.
I have no objection to the combining. I don't see any reason why you wouldn't, only that it's dealing with slightly different purposes.
Yes.
But beyond that, sir, I'm failing to find a reason to argue with that one.
Yeah.
You're quite right. Usually they are sub-specific, aren't they, in terms of the type of signage you see. I think, again, I'd probably have to defer to the LPA on any technical guidance that needs to be followed for those signs.
Any other comments about the signage at Scotland Farm? Thank you. The next point, I think, again, is something we've already dealt with. There's both the condition 31 is requiring that the use of cycle parking is monitored and revised, and condition 30 just requires the local authority be notified, presumably so they can monitor the implementation of the condition. So the suggestion was, could that just be combined into one condition?
No objection, sir, to that.
Moving on now to what's termed as other conditions, buses. Condition 32, I think, seeking to ensure that buses meet a certain standard. It seemed that the second part of the condition was just an explanation rather than a requirement. And again, it's just, I think just to clarify that the intention is that all buses should at least meet the Euro 6 emission standard. I've no idea whether there'll ever be a Euro 7 or something, but is that the intention?
That's absolutely right. So that, and as it says there, it sort of flows from the ES. So
and if so, does the suggestion do what you were seeking to do?
If I agree with the second half, perhaps that is not necessary, but certainly the first half, as a minimum, they must be
Yes.
that level. Yes.
And the reference and the suggestion from ourselves is referring to any other standard that might come in that might exceed the current one.
Because written at the moment, I think it says they've got to be Euro 6 compliant. So
yeah, that's it.
Could that inadvertently require out-of-date buses if there's a Euro 7?
As a minimum, though, sir. So I don't think the condition as drafted would say it had to be, just that as a minimum, and any other product that was on the market that was better would naturally be acceptable, I think, by that condition. But likewise, your wording, if you feel that provides more clarity, by all means, no objection to that.
Okay, thanks. Anything else about the emission standards of buses? Construction hours, we've already talked about that. I think that the only other thing to add, I mean, you've in terms of the startup and close down activities, you've pointed us to the definition within the draft code of construction practice. So I think you've given us some views on that. Because you've identified that the M11 bridge works will probably need to be much more flexible in hours because it's over a motorway. Should the construction hours for that be agreed or set out in a different condition? I think that was the point, really. As in, should something like I don't know, construction hours for the erection of the bridge should be agreed with the local planning authority or something along those lines.
So the answer to that is it's probably not necessary, given the specific provision in the COCP. So it's 3.6 of the draft COCP on PDF 12 makes provision for those extensions being agreed by the LPA. i.e. those extended working hours, I should say. So we can say it's going to be on Saturday evening from whatever time, for example, and that would be agreed through that mechanism.
So your point is that the way the conditions written, with the exception of hours for the overbridge, you're saying that the provisions within the draft construction management plan would cover that.
Correct.
And then presumably the condition we've already discussed, which requires
exactly so
provided.
Yeah.
We pick that up.
That's right.
Okay, that's understood. And then condition 34, which I think was a relatively new condition, which was about trying to limit bus movements at particular times in particular locations, partly in response to, I think, discussions you've had with Claire Hall. It was just there's a few questions there just to understand exactly what the proposals are and the suggestion of perhaps a different way of setting that out.
Yes, and I flagged at the outset, and you've alluded to it already. This is critical from our perspective in terms of the agreed position with Claire Hall.
Actually, just on that, it's critical for your agreed position with Claire Hall. Is it necessary in planning terms? Because I just want to make sure there isn't a difference between
it is
discussion and
it is necessary in planning
yeah?
terms for the reasons that Mr. Lewis explained in his evidence. It's based on the condition that is within his proof of evidence. You recall? Do you want me to take you to that?
No, I recall
you
it.
You recall it, yeah. So he explains the technical justification. Yeah. That is to say, it drops the noise impacts in the absence of electric buses, such that there's no adverse effect. So is there planning justification? Yes, because it removes adverse effects.
Also, just to understand what the intention is, just so I understand it in terms of diesel powered buses.
Yes.
So there's another question is it just buses? But what about other diesel-powered
It
things?
is only buses.
So the next question is, if it's decided to do maintenance on the route in the middle of the night because it's easier, is there a noise thing that needs to be controlled in a similar way, or
There's not the practical answer is because we're not going to be doing maintenance in the middle of the night on the busway, save in the most extreme circumstances.
That may not be your current intention. Is there any?
I appreciate
Is
that.
there a need to control it?
Well,
Road works do take place at night.
they can take place at night. We accept that. But we're saying is there a need here? No, there's not, because the probability of those works taking place on this scheme is so low. That's our answer on that. There was an electric bus point I think you had as well. Do you want me to?
Yeah, it's just, I mean, is the intention that
It only captures those with diesels.
so electric buses could continue to operate?
Correct, and the reason being because going back to Mr. Lewis's evidence, they're so much quieter, the concern doesn't arise, and therefore it wouldn't be justified or necessary to control those electric buses.
So I think that's addressed the third point about the question of a mixed fleet. If there was a mixed fleet, the intention is this would only apply to diesel-powered buses in that fleet, and that the electric buses could continue in an unrestricted.
Because they don't cause a problem, yes.
Just a clarification: was there a restriction on total bus movements or bus movements in each direction?
It's total, sir. So that would be, to take the example of the 9. That would be where 4 go east and 5 go west. They're all called.
Understood. And again, just to make sure, presumably the intention is only on the off-road areas rather than restricting buses on the existing highways.
Yes, I mean that's a good point, sir. The concern is not about buses on the highways. I can put it like that. I understand the point that you make about potential ambiguity on that, but
because if you look at point 3, there's more than one way movement to the west of Bourne Airfield.
Yeah, we understand that, and to be clear, it's the specific concern is about those non-highway sections
of the busway.
Correct. Yeah.
And so, in terms of a sort of suggestion, does that sort of 4-point suggestion effectively deal with the matter and provide the flexibility and the clarity, or is there something that's been missed in
there? So it does capture it. We there's a minor point that in Roman 3, hourly would be deleted for consistency with 2.
Yes, yeah, agreed.
In respect of 4, it seems to us that 4 is a slightly different way of capturing the same thing, but ultimately the substance is
saying that might not be necessary.
No, it would be necessary, sir. But I think we're trying to do the same thing in 2 different ways.
Yeah.
On the substance, we could live with what you've drafted. Not our preferred approach, but I should say, for total clarity, it doesn't reduce the protection that is afforded to Clare Hall. The reason being, when you look at your Roman 2, in Charles Babbage Road and Grange Road, that's the same restriction on the same type of buses, the same number of buses in the same hours.
Yeah.
Just for total clarity in that regard.
Yeah, I think the addition of endpoints was just, for example, if a bus was travelling on through Bourne Airfield, it could turn left or right if it decided to on.
There are other options. Yeah.
Broadway, and therefore there perhaps could be more diesel buses, but just not going down the Stirling Way link.
That's right. It may be a different route. Yeah.
Any other comments anybody wants to make about?
So we just deal with your Water Framework Directive condition. Sure. We're happy for that to be imposed.
Just for those following along, there was questions that I asked in writing earlier in the inquiry about the Secretary of State needing to be confident that it would meet the Secretary of State's Water Framework Directive, or the regulations rather. So that Ms. Hens has just confirmed that this suggesting the condition to require that that would be okay. Yeah, and the next point, which I think might overlap with the discussion we will have on the order, is just about laybys on St Neots Road. Sorry. Oh, have I jumped one? Oh, right. Yes, sorry, 35. We've said that.
Well,
yeah,
tailpieces are to go.
Yeah,
Yes.
and that's not really a condition.
No, understood. And it goes on. I mean, we are allowed, but I think you probably want to ask that question to the local planning authorities, if I may, that they should. This came from them. I can put it like that.
Is the intention behind number 35 just to make sure that no details come in that would actually change the assessment under the ES? Have I understood that correctly?
So, thank you. There was a lot of discussion about tailpieces between the applicant and the local planning authority in the run up to this inquiry. And I think this condition wasn't, as far as I understand it, suggested by the councils, but rather it was a response by the applicant to the local planning authority's concern about tailpieces and to try and restrict the scope of some of the tailpieces that have been included. So if the tailpieces are going, then the local planning authority doesn't see any need for this condition.
Good, thank you. So I think the St Neots Road laybys, obviously this was prompted by the discussion about the lay-by outside the veterinary surgery. I'm just conscious that we've had a sketch plan, but
well, can I just indicate to you our position on that? Agreement has been reached with the vets. That is because of the sealing days. We expect to seal that agreement tomorrow. In those circumstances, our position is that agreement takes care of point raised, and you don't therefore need to move any further to place a condition because that's already been dealt with. It wouldn't be necessary, for example, to take any further steps at that point in time, and there are no other objections or other reasons for requiring the applicant to go any further in respect of the laybys.
Does the agreement relate specifically to the single lay-by outside the vets?
I'm not sure it's a single lay-by, but it relates specifically to the laybys outside of the vets. Yes, it's specific to that
There's only
property.
one between two access points. We had a look at that yesterday.
Yes, but it's a Yeah, sorry. Okay, fine. Well, correct.
and from your understanding, it's there's nobody else who's raised concerns about laybys that you're either aware of or that you want to address.
Yeah, that's correct, sir. Well, I should say that's unsurprising, given those laybys are already within the highway. They're not, for example, owned by any other party. We could, I'm not saying we would, but the principle is we could go along tomorrow and use our permitted development rights in our highways plan to alter that arrangement if we chose to do so. So it's unsurprising in that context that we haven't had anybody else saying or raising a specific objection. The vets is a special case which we've addressed.
If the view was taken that actually there was a material planning necessity to retain a lay-by to the front of the vets, how would that line up with an offline agreement that you've got with the vets? Are you saying that this isn't addressing a planning issue? It's more addressing an issue with the vets have raised.
Yeah, precisely, because they're concerned about their yes, but you just wouldn't need to go that far because it's already been captured. So why would it be necessary to impose a condition when adequate alternative provision has already been made? It just wouldn't be.
And I take it from what you've said, Mr. Henderson, that there will be an objection to any broader condition.
Correct. Yeah, I should say, Mr. Cameron reminds me, I was about to say it, I bottled it, but I'll say it anyway. The reason being because they're concerned about essentially a commercial interest they have, and we've reached an agreement in order to mitigate that concern. It doesn't go to a use, take it all the way back. Does it go to the character and the use of the land? No, it's a commercial issue that they've raised. See, right, Forge of Dean, etc. All of this.
Thank you. Is there anything else anybody wants to say about St Neots Road?
I think the only other point is you expect the agreement to be sealed by tomorrow.
We do so, yes, because that's the sealing day for the County Council.
Is it a confidential agreement or can it be submitted?
I suspect it is confidential, but we could arrange for a letter.
Into terms?
A letter in an agreed form that gives you the detail to explain the headline points, which should be absolutely fine. We'd have to talk to the vets.
Yes.
But their solicitors are engaged with one Dickinson, and we can get onto the case so that you get at least a feel for.
We'd like a flavour of the agreement.
Yeah, I should say you can probably have a pretty good guess as to the sorts of arrangements that are contained within it. But we can, if you leave that with us, and I said that we'd write to you on the conditions point anyway. We'll try and write to you separately on that specific point as well.
Okay, thank you.
Thank you.
Questions? Is anything we haven't covered?
One final question that just after we carried out our accompanied site visit, there's conditions specifically dealing with the avoidance of damage to retained trees. Clare Hall, the works are happening fairly close to the listed building, and because of its design with canals and waterspout features, is there a need to be sort of explicit about protecting the listed building during construction works? I'm not talking about in terms of the final the final scheme. And also there was reference to the potential for replicating the paving patterns in any new links to the south. There was a discussion, I think, with Mr. Wilson, who's as to whether or not they were within the curtilage. You say they were in the curtilage. So again, where would that be covered in the conditions? And if it isn't, do we need to provide a particular arrangement for it?
Well,
so one's construction effects. Yeah. The other one is any proposals to replicate the footpath links, which are sort of beyond the curtilage of the listed building.
Well, on the construction points, we go back to conditions 8 and 9, the COCP. That includes, for example, in the COCP, paragraph 310, specific reference to hoardings and fencing. So making sure that is in place in that location, for example, would fall within that element. And on the pattern, well, that's a detailed design point. You've got hard and soft landscape, and I think we already directed you to that when this point was raised at the time. And it would simply be dealt with in that way by the local planning authorities considering what was appropriate.
So on that, as I think you've said on other things, that would be something for the applicant to either indicate or not indicate on the designs, and if the council were happy with it, they'd approve it, and if they weren't happy with it, they wouldn't. Is that
exactly so, sir? Yeah.
Thank you. Can I just ask to see if there's any other comments on conditions that anybody wants to raise?
Sir, I have one more. I'm sorry.
Mr. Burford.
As you know, my main concern is my wife's health, and I would like, possible, some kind of air monitoring apparatus placed in my garden 2 months prior to construction and during construction.
Well, I guess the first question to the applicants is there any provision for such arrangements? Actually, and yeah, actually, as Mr. Glegg saying, is that something that would actually be picked up in the construction dust management and monitoring plan? Because that does obviously include monitoring.
Yeah,
provisions.
that would include monitoring locations, sir. There's also paragraph 5.2.1 of the COCP deals specifically with the monitoring of air quality.
Mr. Burford, it might just be helpful if I read out what's been suggested. It may have been mentioned this morning before you arrived, but there's a suggestion for a condition which would say that a construction dust air quality assessment, management and monitoring plan that will be required to provide an assessment of dust and air quality impacts associated with the construction process. The plan must also set out the proposed air quality inspection and monitoring procedures to assess the effectiveness of measures to prevent dust and pollutant emissions during construction. So that's what the applicant's suggesting. The local authority who would deal with conditions are here. They'll have heard both that condition and your concerns. And when a plan would have to come in for approval, assuming the scheme went ahead, and the local authority would no doubt take account of concerns in relation to that.
Yes, so that goes a long way towards it. My only question would be, where would the measure take place? Because it's no point measuring it up a Bourne if the construction and the pollution is immediately outside my property. And I'm saying this because clearly of my wife's condition.
Yeah, no, I completely understand what you say. I think this goes back to perhaps what we were talking about before, where I think you would like to see something explicit in a condition that says the applicant is to provide a monitoring station in my garden at these periods. I think not going to put words in the applicant's mouth, they're saying, well, the condition as it's written requires that that managing and monitoring plan to be agreed, and that's when the details will be sorted out. And as Mr. Clegg said, obviously the condition doesn't say Mr. Burford must be consulted on these, but we wouldn't normally expect conditions to say that. But so there is obviously that issue that the expectation would be for how at the end of the day the council decides to deal with any details that come in. But as Mr. Clegg said, they've heard what you've had to say. Obviously, at the moment, we don't know whether the Secretary of State's going to make the order or not. It may be the thing that actually further down the line, if the order is made, that and again, I can't speak for the local authority, but you may want to make representations to understand how they intend to do it. That I can't give you any guarantees because we're talking about sort of various what ifs, and I'm not the local planning authority, so I don't deal with their arrangements, their policies, or what have you, and I can't tell them to do things here. But all I'm saying is that I think, just to follow on from what Mr. Clegg said, that if the Secretary of State makes the order, if the Secretary of State put on a condition that requires a dust monitoring, dust management and monitoring plan, and obviously it comes back to that the applicant may say, here's our draft plan, look at it. They may not. The local planning authority may say, well, I've got this plan to look at. Can you say something? You may or may not. I can't. We can't do these things because that's sort of beyond what.
I think the point is, Mr. Burford, there's a clear mechanism for doing what you want.
Yeah. Thank you. Is there anything else that anybody would like to mention about conditions? Thank you very much. I realise we've actually taken quite a considerable time on conditions, but that's been very helpful in understanding exactly what various parties' positions are. I think because of the time, we'll have a break for lunch before going on to the order. I'm conscious also that certainly some parties are probably still looking at information to come back on in terms of having the opportunity to look at the order. If we had a constrained lunch of half an hour, would that cause any parties any particular issues other than not having much time to eat your sandwiches?
No, sir.
I mean, if you're looking to us, we don't have any comments on the order or the information being submitted, so no need to account for it.
Okay. And also, I think at the start there was we we'll come back to you, Mr. Parker, in terms of your comments in light of the applicant's note about the back mitigation, but before we get to closings, because obviously I don't. Once we get to closings, I don't want to hear anything more about evidence, etc. So yeah. So in that case, we shall adjourn now, and we'll resume at 1:45. So thank you very much.